Good morning, everybody. Welcome to TCF Live. My name is Dan Soul. I'll be your guide for this morning's journey through Courtlandia. But before we get started, here's a little about me. I'm a modern man, a streamer and a dreamer, a courtroom man, a 2-laptop, 4-monitor, big board running, no AI slop, real human commentary kind of man. I'm gavel watching, chat moderating, orange jumpsuit spotting, payment plan explaining, judge roasting, defendant excuse wrecking, live streaming truth seeker. I'm online and off the bench. I'm hibernating behind the screens, cat co-hosting with Ellie, super chat reading, fact-checking the finds and the lies. I'm loud in the cloud and louder in the comments. I'm hypercritical of bad rulings and occasionally hypocritical when my own hot takes land sideways. Mad about the nonsense and part of the law too base. Attention-seeking with thumbnails and anonymous in the Discord. I'm anti-slop, pro-real, unscripted, and unedited. I've got no use for fake voices or manufactured drama. I've got zero patience for the sensational. I'm a prayer warrior at the end of every show, an anti-AI crusader, and court procedure invader. Deep-dived and fully committed, brand loyal to the gavel. My notions are preconceived by the transcript, and I still love to be surprised anyway. I'm a wife-supporting, kid-raising family man with a belly and a plan. A 53-year-old self-employed, self-driven dreamer pulling 12 to 16-hour days. An alpha powered by stubbornness and sheer willpower. I'm being buried in court feeds, and I won't shut up about it. I'm a true believer in personal accountability and an underachiever at keeping any stream under 3 hours. Part of the conversation, but impossible to talk down, outraged by weak stories, and part of the in-group that actually shows up. You can't shut me up. You can't talk me down because I'm far right on the docket, far gone on cases, and far behind on sleep. I'm oversharing and undercaring about payment plans, pro-gun, pro-accountability, anti-bullshit kind of guy. I'm not mad online, I'm just watching. Everything's fine. I commit to the bit, I commit to the chat. I'm circling back to the cases, getting aligned with the rulings, staying media illiterate on purpose because the raw transcript is all I need. I'm high-touch, low-impact, subscription-based, gig economy, algorithm fighting, and preserving the real. I like my entertainment raw, all courtroom just for me. I doom scroll the dockets, I chat troll the nonsense. I'm tuned in on my big board. I pretend like piety from the defendants is something I'm interested in, but I have zero production jitters. I'm typing and tapping, streaming, interacting, swiping and clicking, lying to no one. Ego inflated by the super chats and self-sedated by the end of the show's sign off. A lone wolf who's part of a damn good pack. And with that, let's roll, nerds. Good morning once again, everybody. We'll get our day started with Magistrate Urich.
Good morning. Welcome to the 44th District Court. We are about to commence a traffic docket. If you are here for a civil infraction issued by Officers Francis, Stokes, Gertler, or Patron of the Royal Oak Police Department, you are in the right place. Please listen carefully. The court is going to explain the informal procedure to you as a group, and then we will undertake your cases one at a time. So to begin with, folks, these are civil infractions of a non-criminal nature. Nobody's going to jail this morning on their traffic ticket, but it is considered serious enough that the citing officer issued you the ticket on the date in question. As the motorist, you will be required to make a selection from one of 3 options and 3 options only to protect your own rights. You may, if you wish, simply admit responsibility. The court will attach a scheduled fine anywhere from 0 to the maximum, and that'll close the case. You may also, if you wish, admit responsibility, but with an explanation that you believe mitigates your circumstances. Your third option is to deny responsibility. That is absolutely your right and your privilege if you do so. The court will swear the parties under oath. The officer will testify first. It's their burden of proof today. Then it is your turn to testify. And then the court makes the finding of responsible or not responsible. But please recall that since we're in civil court, that burden of proof on the people is a mere preponderance of the evidence, otherwise known as the featherweight test. That heavy burden of guilt beyond a reasonable doubt is reserved for criminal court, and these are not criminal charges. So with that said, the court would simply add that if you have a documentary case involving proof of insurance or expired plates and you have taken care of your situation, have that proof of documentation handy, and that will expedite your matter. So the court's going to excuse you, bring you back one at a time. Please be ready with your selection. Thank you. And the court calls case number 26 RO 02407. This is People versus Jordan Amanda Barnett. That's you.
Correct. Yes.
Ms. Barnett, welcome. You were present just a second ago when the court explained the nature of an informal hearing. True?
True. Yes.
So you understood the court to instruct that you must select from one of three options to protect your own rights, correct?
Yes.
Thank you. Ms. Barnett, the citation for the court was issued April 18 this year at approximately 10 in the evening. You were operating 2019 Cherokee black in color on Woodward Avenue M1 at or near 14 Mile Road in the city of Royal Oak. At that place and time, it was discovered the vehicle's plate had expired on your birthday last May. So this is a simple non-moving 0-point violation of expired plate. You may admit responsibility. You may admit, explain, and display an updated registration, or you can deny responsibility and the court will swear the parties and conduct your trial. What do you wish the court to do for you?
I admit, and I have my registration in front of me.
Very well. So you're confirming to the court that on the date in question you're operating a motor vehicle in the city of Royal Oak with an expired tag, correct?
Correct.
Okay. Officer Francis, might you have checked this before today?
Oh, yes, Your Honor, I did. It's all up to date. So with that, I'd like to make the motion to dismiss the citation.
All right. Well done, Ms. Barnett, and a recent happy birthday for you. This one is going to be dismissed. You know what to do each and every May 7th for the next 75 years, right?
Yes.
All right. You take care of it.
Thank you. Thank you, Your Honor.
Calling case number 26 RO 02252. This is People versus Lupus William Post. That's you, sir?
Yes, sir.
Thank you very much, Mr. Post. You were present earlier this morning when the court explained the nature of an informal hearing. True?
Yep.
So you understood the court to instruct that you must select from one of three options to protect your rights. Also true?
Yes, sir.
Thank you very much. Mr. Post, the citation before the court was issued on April the 14th of this year at about 8:30 in the evening. You were operating a 2006 Honda, blue in color on Woodward Avenue, M1 at or near Bamlick, City of Royal Oak. At that place and time, you were cited for driving without your headlights illuminated and having a large obstructing object hanging from your rear view mirror. So the officer's remark indicates observed northbound Woodward with lights off, etc. There's a warning that's not before the court regarding your registration, but regardless, today's your day in court on the lights issue and the rear view mirror object. You may admit responsibility, you can admit and explain, or you can deny responsibility and the court will conduct your trial. Mr. Post, what do you want the court to do for you?
So I'll definitely admit my responsibility, but I was wondering if there was any way to get the lights taken off because it was still somewhat bright out, and I always make sure I have my lights on, but it was just he didn't even give me time to like realize it was getting dark out, you know?
The court doesn't have the authority as the neutral here to just quote unquote take a ticket off.
Right.
If you believe you're not responsible for having your lights off at dusk, you can certainly conduct your trial today if that's what you wish to do, or if you wish to confirm that you are legally responsible, but then explain it in the way you just did, that's your right and privilege too. But the court does need to take a plea on both of these before it can proceed. So you can admit and explain, or deny responsibility.
What's the difference between admitting and explaining?
Well, if you admit, you just say yes, and then the court assesses a fine within its discretion. If you admit and explain, that's certainly something that the court can consider when it's analyzing what sanction might be necessary. And certainly the officer is free to make any motions they wish based upon your explanation.
Yes, sir. I'll explain.
Well, you can explain, but again, it has to be in a context. Do you wish to admit and explain?
Yes, sir.
Very well. So you're confirming to the court that on the date in question, you're operating a motor vehicle in the city of Royal Oak. You did not have your lights illuminated at dusk, and as well, there was an object, an obstructive object hanging from your rearview mirror, correct?
Yes, sir.
Thank you. The court is very grateful for your plea and honesty. Mr. Post, what's going on? What do you want the court to know?
So I was driving down Woodward and it was just getting dark out, but there was still sunlight out. It wasn't really it wasn't dark yet.
Mhm.
And he pulled me over for it. And I didn't even get a time to turn off my light or turn on my lights yet.
Mhm.
And every other day I'm driving with my lights on. I always make sure to turn my lights on, but it was almost instant.
You don't mean every other day, like odd even. You mean every other day except for this day.
Yeah, every time I drive.
Okay. All right. And what was the object hanging from your rearview mirror?
It was a small little angel. It was my grandma's car, and she had it was a little angel.
Okay. Thank you very much for that.
Yep.
The court appreciates your statements, and the court would turn to Officer Francis.
Your Honor, as for the lights, it's a common thing sometimes to forget, right? People forget things. So, with that being said, I'd like to make the motion to dismiss that citation, and then nothing further for the dangling ornament.
Okay, thank you very much. So, Mr. Post, being a weather nerd for a moment, sundown on that particular date was actually 12 past 8.
Okay.
And I think that the hard rule basically is you can't wait till last light to put the lights on. You gotta put them on when the sun goes down, the lights go up. Do you have the sentinel or automatic feature on your lights on that vehicle?
No, sir. I gotta flip a switch.
Okay, well, that one's dismissed.
Okay.
And with respect to the object, stand by. The court's going to reduce that fine significantly. So, your fine on that is going to be $75, Mr. Post. That is payable through the pay portal on the 44th District Court website. Or you can walk the cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. Of course, marking that due within 14 days. That completes your hearing, and this was a teachable moment. So the court intends to not see you again in this context. Okay?
Yes, sir. Have a good day.
Good luck to you.
Good morning once again, everybody. It's TCF Live. It's Monday morning. It's nice to have you all here. As is typical on a Monday, fairly slow start out there in Courtlandia. We're going to continue to ride with the magistrate here for a little bit.
Calling case number 26, RO 01906. This is people of the city of Royal Oak versus Luke Michael Neshwat.
Neshwat.
Neshwat, thank you very much. Mr. Neshwat, you were present earlier today when the court explained the nature of an informal hearing. True?
Yes, Your Honor.
So you understood the court to instruct that you must select from one of three options to protect your own rights. Also true?
Yes, Your Honor.
Thank you, Mr. Neshwat. The citation before the court was issued by Officer Francis on April 3rd at 9:30. You were operating a 2025 BMW gray in color on Woodward Avenue, M1, entering Buckingham City of Royal Oak. And at that place and time, you were cited for a violation of the basic speed law. The officer's remark, which appears on your ticket, indicates vehicle observed northbound, Woodward near Normandy, driving in right lane, clearly over the posted 45-mile-per-hour speed limit. Violation of basic speed law, otherwise known as also driving too fast for conditions, is an overarching requirement under the Michigan Motor Vehicle Code that means drivers must drive at a safe and prudent speed at all times on any Michigan highway, based upon the conditions, lighting, etc. So it's not a particular margin of speed, as much as the officer's assessment of the circumstances. Mr. Neshwat, you may admit responsibility, you can admit and explain, or you can deny responsibility, and the court will swear the parties and conduct your trial. What do you want the court to do?
I'd like to admit responsibility with an explanation, Your Honor.
Very well. So you confirming to the court that on the date in question, you're operating a motor vehicle in the city of Royal Oak, and you drove in violation of the basic speed law, correct?
Your Honor.
Thank you. Mr. Neshwat, what's going on?
So it was a very busy night on Woodward. There's like a big like car thing going on, I guess. And I was in the right lane. The vehicle in front of me was turning right into like a neighborhood, and they came like extremely slow. Like they almost came to like a full stop. So I kind of just accelerated to catch back up to traffic. It was all moving quick, and I didn't mean to do it aggressively or anything.
Okay,
But
so you weren't drag racing.
no.
Okay, well, make sure you don't do that, because that's actually a crime. Mr. Neshwat, court has zero idea what your driving record looks like. How long have you been driving?
I've been driving since I turned 16, so like September 2023, I think.
Good for you. Thank you. Officer Francis, what would you like to share?
Your Honor, I'd like to make a motion to amend this to impeding traffic.
Okay, impeding traffic, Mr. Neshwat, is a 0-point violation, will not appear on your master driving record permanently. That's acceptable to you?
Yes, Your Honor.
Very well. So your plea to violation basic speed law subsumes a plea to impeding traffic. The fine is $175, payable through the pay portal on the 44th District Court website, or you can walk the cash check or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. And that is going to be due within 14 days. That completes your hearing. Good luck to you.
Thank you, Your Honor. Have a good one.
You as well. The court calls 26 RO 01599 and M 026128. People versus Crawford and People versus Kennan, respectively. These matters were set for 8:30 with Officer Francis. It is now nearly 9 o'clock. Neither party has made their presence known to the court, so the court will mark these as failures to appear and defaults will enter. And Officer Francis, I believe that would complete your business.
All right. Thanks, Your Honor. Have a good day.
You as well, sir.
Thank you.
Alrighty, friends. Good morning once again. TCF Live. Good to have you here. Let's go to Huron County. Judge Prill has a contestant. Let's see what's going on with him.
File number 267450F, age, time, and date set for Raymond. Mr. Schultz is present, represented by Attorney Michael A. Morosky. People are represented by Prosecuting Attorney Timothy J. Rukowski. Mr. Morosky, have you received a copy of the information that's been filed in this case? Have you and your client had the opportunity to review it, and do you waive the reading as well?
Yes, Your Honor, Mr. Schultz and I did review it, and we're waiving the reading there of this today.
Thank you. My understanding, there may be a plea agreement. Is that correct?
Yes, Your Honor.
Thank you. Mr. Schultz, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes, ma'am. Thank you. Mr. Rukowski, would you please state the terms of the plea agreement on the record?
Yes, Your Honor. Mr. Schultz, if he's paid all the restitution back to the victim, including the tow and storage fee, people would agree to a 1-year delay of sentence. If the defendant successfully completes that delay of sentence term, the conviction would enter as larceny 200 to 1,000 in 1 year.
Mr. Morosky, is that your understanding of the plea offer?
It is, Your Honor.
Mr. Schultz, did you hear the terms of the plea offer outlined just a moment ago?
Yes, Your Honor.
And that's your understanding?
Yes, Your Honor.
Do you wish to accept that offer?
Yes, Your
Are
Honor.
there any other terms of this plea offer that we've not covered on the record?
I'm aware, Your Honor.
Mr. Morosky,
I agree.
Mr. Rukowski.
It's a no contest plea to Your Honor.
Thank you. Appreciate that. No contest plea. All right. Mr. Schultz, have you had sufficient time to speak with your attorney about this?
Yes, Your Honor.
Do you need any additional time to speak with Mr. Morosky?
No, Your Honor.
Anything affecting your mind or brain making it difficult to make important decisions?
No, Your Honor.
You have a clear mind?
Yes, Your Honor.
In the information, you were charged with false pretenses, $1,000 or more, but less than $20,000. That is a felony carrying a maximum prison sentence of 5 years and or a fine of $10,000. Do you understand the charge and maximum sentence?
Yes, Your Honor.
Very well. Understanding that then, Mr. Morosky, how did your client plead to the charge of false pretenses, $1,000 or more, but less than $20,000 on or about November 3rd, 2025, Lake Township, Huron County, Michigan?
No contest, Your Honor.
Reason for the no contest.
Pretends a civil liability.
Any objections?
No objection, Your Honor.
That is a proper basis to proceed in that fashion. Mr. Schultz, the court is in receipt of an advice of rights form. Did you sign this document, sir?
Yes, Your Honor.
Now, before signing it, did you read it over?
Yes, Your Honor.
Did you also go over it with Mr. Morosky?
Yes, Your
Do you understand the rights on the form?
Yes, Your Honor.
By pleading no contest, you're giving up those rights.
Yes, Your Honor.
It means you will not have a trial of any kind nor have any opportunity whatsoever to contest your guilt. A no contest plea is tantamount to you admitting your guilt, and all that remains after today will be for you to be sentenced.
Yes, Your Honor.
If this plea is accepted, you'll be giving up any claim that this plea is a result of any promises or threats not disclosed to this court during this plea proceeding. You'll also be giving up any claim this plea is not of your own free choice.
That's all right.
That's okay, we can do it again. By pleading no contest, you will not have, well, let me back up. You'll be giving up any claim that this plea is a result of promises or threats not disclosed to this court during this plea proceeding. You understand that?
Yes, Your Honor.
You'll also be giving up any claim this plea is not of your own free choice.
Yes, Your
So in other words, if you came back later and said, Judge, I had no choice, I had to do this, I was forced to do this, now's the time to tell the court.
Honor. I understand.
All right. Other than the terms of the plea agreement outlined on the record, has anyone promised you anything such as leniency to get you to plead no contest?
No.
You understand that no one can make any promises from the court as to how the court will dispose of this case. That is, no one can promise easy on you imposing sentence. You understand that?
Yes, Your Honor.
Does anyone promise the court will be easy on you?
I'm aware of that.
All right. Does anyone threaten you to enter this court?
No, Your Honor.
For your own free choice. Court costs are due and payable at the time of sentencing unless there's good cause shown. Are you aware of that?
Yes, Your Honor.
And that you're subject to a 20% late penalty for any unpaid court costs due 56 days following your conviction and sentence.
Yes, Your Honor.
Finally, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Further, any appeal from the conviction and sentence pursuant to this matter, that is, will be by application for leave and not by right. You understand that? Yes, sir. Again, Mr. Schultz, any question regarding any of your rights? No, you're not. Any questions of Mr. Morosky? Mr. Rakowski, would you present something?
Yes, Your Honor.
Any objection to People's Proposed 1?
No, Your Honor.
People Proposed 1 is Huron County Sheriff's Department Incident Report 25,096.90. The court will review. Mr. Rakowski, where we promised threats or inducements for this, the other one.
No, Your Honor.
No, Your Honor.
Has the court complied with the court rule concerning pleas, Mr. Rakowski?
It has, Your Honor.
It has.
Mr. Schultz, there's no agreement made by this court concerning the plea with the final result will be. Is that accurate? Rusty, you
I agree.
Mr. Rakowski?
Yes, Your Honor.
Court will accept the plea. It's done freely, it's voluntary and understanding. A sufficient factual basis is going to be provided by People's Exhibit Number 1. The plea is accepted. We will schedule sentencing for
We will be available.
sentencing July 13, 2026 at 9 a.m. Prior to sentencing, the court is ordering a pre-sentence investigation and report to be prepared, provided to both counsel and the court at least 2 days prior to sentencing. Sentencing guidelines shall be scored 14 days prior to sentencing, provided to counsel. Any objection to the scoring of the guidelines must be filed in writing with the clerk of the court no later than 7 days from sentencing, as well as notice to the probation department. Mr. Schultz must appear in the court at the time of sentencing. If there's any supporting documentation, it may be submitted to the court no later than 7 days from sentencing. Any objection or written response must be filed 3 days thereafter. Bond was set $3,500, 10%. It's been posted. Mr. Rakowski, your position on bond, sir?
No objection, continuing bond.
Mr. Rossi?
We ask that bond be continued.
Bond will continue to as previously said. Mr. Schultz, that'll be all. All right.
Coach.
Yes.
Alrighty, everybody. Good morning once again. Good to have you all here with me on our journey through Courtlandia. Let's go to Crawford County. We'll say good morning to Judge Colin Hunter.
You were picked up on that bench warrant. I issued an order remanding you to jail until I can schedule this hearing for today. Since you've been in the jail, have you been able to maintain contact with Mr. Thompson?
I haven't seen them since last court date, so that would be a no.
Mr. Thompson, were you aware that Mr. Colvin was lodged?
Yes, I don't agree that I haven't seen him since the last court date.
When did you last see him?
I don't know that I have the date here, Your Honor, but I definitely saw him on the Zoom system. Since he's been relived, I want to say 3 times. I believe I saw him in person at least once. I've sent him 3 separate letters.
Mr. Colvin, did you wish to respond to that?
I haven't seen them since our last court date.
I don't find your suggestions very believable, Mr. Colvin, and the reason I say that is a combination of a ton of different factors. Number one is this case started in July of 2025. There has been nothing but difficulties between you and the court, and more specifically between what you have done or not done with respect to court orders. There's been issues with drug tests. There's been issues with failure to appear. Most recently in February, I had a court hearing where you told me you wanted to hire new counsel. I told you I'd give you a month to do that. I set a new hearing in March and you failed to appear. Even after you failed to appear and a bench warrant was issued, it took nearly a month before officers were able to locate you. You've been in the Crawford County Jail by my order that I signed. You were remanding to jail on March 26th. That means 8 days short of 2 months you've been in the Crawford County Jail. You said you haven't seen your attorney or talked to him since the last court date. I don't find that particularly credible, especially when balanced against Mr. Thompson's assertion on the open court record as an officer of the court that he's sent letters to you, he's met with you in person, and he's met with you via Zoom all since you've been lodged in the jail. So to the extent your claim is you haven't talked to your attorney, I lay that blame at the feet of the person who it appears most likely to be at, logistically, legally, and factually, and that's you. So it's unfortunate that you've not maintained contact with Mr. Thompson, but it's the court's strong view that that's a plan by you. It's an assertion, a reassertion of the statements that you made before, which is you were planning on hiring new counsel. And it's the court's sense that your hope is I'll simply adjourn and not do anything since you haven't done anything to be able to be prepared. But the court does not choose to grant that request, whether it's made expressly or implicitly. I'm going to set all of these matters for trial, and I don't intend on having any additional hearings. I'm going to hear from the attorneys which case needs to be set first, but the time has come and passed for any further discussions. This case is almost a year old, the oldest, and you've continually been, again, problematic during the bond time. So no bond is going to be issued and the case is going to be set for trial. Ms. Cope, from the people's standpoint, which case should be calendared first for trial?
I think it's the oldest.
Mr. Colvin, did you wish to make a statement?
I had planned on accepting the plea that was offered. Like I said,
Well,
I
how
have
could you
not
accept
talked.
the plea, Mr. Colvin, if you've not even talked to your attorney?
He told me the plea that was on the table the morning of our, the last time he came and saw me. That was right before we went and had it, and you adjourned it because of all, what do you call it? The things that were happening outside, the storms and everything. So we adjourned it that day for another month. You pushed it out, and he told me what the offer was. He came and seen me a week before the last court date. That's the last time I've seen it.
Mr. Thompson, did you want to state for the record the most recent plea offer that you're aware of?
Yes, I'll put the record on, Your Honor. So in 5448, which is the oldest file, that file would be dismissed if Mr. Colvin accepts the global offer. I'm sorry, 54448. So 5527 be a guilty plea to count 1. That's delivery or manufacture of methamphetamine. Dismiss all the additional counts and dismiss the habitual offender status. In 5528, likewise, guilty to count 1, which is larceny in a building, and then dismiss all the habitual offender enhancements.
Mr. Colvin, is that the plea offer that you were aware of and that you were just bringing up?
Yes, Your Honor.
And should the court decide to go forward with it, is that your plan? Is that you wanted to take advantage of those plea offers?
Yes.
So this matter is somewhat, I think, up to the court as well as the prosecutor. And I say that because I set a plea cutoff. Did the people wish to be heard on whether or not I should allow a plea to be accepted on today's date?
He tried to enter a plea last time and there was some confusion, so we had to adjourn it. It was a question about what the actual plea was. So the plea is, it's P-wood meth, which is the same as delivery manufacturer meth, and there was some confusion about that. So I would think the court should probably accept the plea because we had to adjourn it because of the confusion.
Mr. Colvin, did you want to enter a guilty plea under the terms that your attorney just outlined?
Yes.
Raise your right hand, please. You solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Colvin, this plea involves 3 different files. One of the files, the one that originated back in, at least for this court's date, in July of 2025 would be dismissed. Are you aware of that?
Yes.
So that would be the charges of possession of methamphetamine as a habitual third, operating while license suspended in open container of alcohol in a motor vehicle. Those would all be dismissed. Do you understand that benefit?
Yes.
In the second file, which is 26-5527 FH, you would be pleading guilty to count 1, which is entitled controlled substance possession with intent to deliver methamphetamine. Are you aware of that?
Yes.
Possession with intent to deliver methamphetamine is a felony offense, and the maximum punishment for that felony offense is up to 20 years in the state prison system and or a fine of up to $25,000. Are you aware of that?
Yes.
In that particular file, the prosecutor would then dismiss all of the other charges and the enhancements. So the habitual offender third offense notice would be dismissed, so would weapons carrying concealed, and so would the driving while license suspended charge. Are you aware of the benefit of having those other matters dismissed?
Yes.
In file 26-5528 FH, the prosecutor would offer that if you plead guilty to count 1, larceny in a building, she would then dismiss the habitual offender third offense notice. Are you aware of the benefit of the plea?
Yes.
Larceny in a building is a felony offense. The maximum punishment for that felony offense is up to 4 years in the state prison system and or a fine of up to $5,000. Are you aware of that?
Yes.
If the court determines that you were on felony bond when you committed a new felony, then the court would have its discretion empowered to sentence you consecutively. Do you understand what consecutive sentencing would mean?
Yes.
If you were on parole when you committed a new felony offense, then there's mandatory consecutive sentencing. Are you aware of that?
Yes.
So do you understand the maximum penalties, both for possession with intent to deliver methamphetamine as well as larceny in a building?
Yes.
You understand the benefit of the plea agreement across all of these 3 files?
Yes.
As to the offense of possession with intent to deliver methamphetamine, how do you plead?
Guilty.
As to the offense of larceny in a building, how do you plead?
Guilty.
If you plead guilty, you no longer have any automatic appeal rights. Instead, your appeal rights are limited. You would have to ask the Court of Appeals for leave to appeal. Are you aware of that?
Yes.
If you plead guilty, you give up all of your current trial rights. Are you aware of that?
Yes.
Trial rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving you're guilty beyond a reasonable doubt. At your trial, you would have the right to have the witnesses against you appear and to see, hear, and question them. And you'd have the right to have the court order any witnesses on your behalf be ordered to appear at trial. You'd have a right to remain silent during your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But by pleading guilty, you waive and give up those rights. Are you aware of that?
Yes.
Because you're giving up the right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if there was a trial. Are you aware of that?
Yes.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No.
Are you pleading guilty freely and voluntarily?
Yes.
Is it your own choice to plead guilty?
Yes.
The prosecutor claims with respect to the possession with intent to deliver methamphetamine charge that happened on or about November 13th of 2025 here in Crawford County. First, do you think that date is accurate?
Yes.
On November 13th of 2025, were you present in Crawford County?
Yes.
Did you possess the controlled substance methamphetamine?
Yes.
Did you know it was methamphetamine?
Yes.
And did you intend to deliver it to someone else? It's not a complicated question, Mr. Colvin, given that you offered to plead guilty to possession with intent to deliver. So I'll ask it again and I'll slow down. Did you possess methamphetamine on November 13th of 2025 in Crawford County?
Yes.
Did you intend to deliver it to someone else?
No.
Then how would I possibly find you guilty by way of a plea?
Because that was the plea that was offered.
So I would find you guilty because the prosecutor offered a plea and not because of what you tell me. Is that your intention?
That's what's being offered, and that was the best deal on the table for me, Your Honor.
Mr. Colvin, I have every reason to believe that you're being difficult on purpose. I'm not going to permit you to be difficult on purpose. This is a simple process. You told me you wanted to plead guilty, and now you're telling me you're not guilty. Last chance, if you want to plead guilty, only because you are guilty. Otherwise, I'm going to set the matters for trial. It does not matter to me how the case resolves. It does matter to me that it resolves, though. And it's going to be resolved either by trial or by plea if you tell me you're guilty, but only by plea if you tell me you're guilty. Otherwise, I am statutorily and constitutionally prohibited from accepting a plea. So you get to determine how we proceed next. I can only accept the plea if you tell me you're guilty of what you're telling me that you're guilty of.
Yes, Your Honor.
Guess what?
Yes, I'm guilty.
Did you possess methamphetamine on November 13th of 2025 in Crawford County?
Yes,
When you possessed it, did you intend to deliver it to someone else? Is
yes.
there any question in your mind about that?
No.
Are you sure?
Yes,
Is it also accurate that on January 5th of 2026, you were present in Crawford County?
yes,
On that date, did you steal Apple iPhone 14 from a building?
yes,
And when I say steal, I mean you didn't have any legal authority to take it and you did take it. Is that accurate?
yes,
Counsel, is there an adequate factual basis?
Yes.
Yes, Your Honor. Do the attorneys believe the court has complied with the court rule regarding the taking of pleas?
Yes, Your Honor.
Yes, Your Honor. Are either one of the attorneys aware of any promises, threats, or inducements not disclosed on the record?
No, Your Honor.
No, Your Honor. Mr. Colvin, I accept your pleas. I find them to be freely, knowingly, and voluntarily given, and there's a clear factual basis now for me to accept a finding of guilt as to each count, and I will accept those pleas. The next step is the Department of Corrections is going to reach out to you while you're there in the jail, and they're going to interview you. That interview will result in what's called a pre-sentence investigative report that will tell me more about you and more about these events. And then I'll impose sentence. The sentencing hearing will be in person, and you'll get a notice for that in-person proceeding very soon. That will be here in the Crawford County Courtroom. Everybody will be present in person. Do you have any questions about any of that?
No.
Mr. Thompson, do you have anything further?
Nothing further for today's record, Your Honor.
Thanks, Cope. Do you have anything further?
No.
That's all for today. Thank you, Mr. Colvin.
Is he actually guilty? Very good question. Now that was murky and muddy and messy. Good morning once again, everybody. It is TCF Live. Let's head back to the Thumb and Judge Prill. Interestingly enough, this new contestant seems to have shopped off the exact same Walmart rack as his previous contestant. They're dressed pretty much exactly the same.
Time of day set for defendant's sentencing. Mr. Bender is present, represented by attorney Kyle T. O'Mara. People are represented by prosecuting attorney Timothy J. Burkowski. Back on March 23rd of this year, the defendant had pled no contest to operating while intoxicated. Their defense pre-sentence report has been prepared by Ms. Karen Everland, dated May 5th, 2026. Mr. O'Mara, you and your client had the opportunity to review the pre-sentence report. Yes, Your Honor. Any additions, deletions, corrections, objections? None, Your Honor. Any to the guidelines? No, Your Honor. Sir, do you agree with that? Yes, Your Honor. Mr. Burkowski, any objection to the report as well as guidelines? No, Your Honor. Okay. Mr. O'Mara, anything you'd like to say on behalf of the defendant before the court imposes sentence?
Yes, Your Honor. As indicated in the report, this is a true third offense of note. I believe Mr. Bender's most recent conviction was nearly 12 years ago, so it's been some time. He did previously participate in and successfully complete his prior court program. Mr. Bender reports extended periods of sobriety. He acknowledges he has a problem. There's no question as to whether or not he can return to using alcohol or not. Unfortunately, in this circumstance, Your Honor, there's really been a lot of unfortunate circumstances kind of piling up in Mr. Bender's life, details of which for his privacy he's asked not to get into the court. But unfortunately, those things really kind of snowballed, and he made the poor decision to cope with that, self-medicate with alcohol. I'm really pretty confident that Mr. Bender is going to do well on probation. He's respectful, works hard, he's disciplined, he's pleasant to deal with. I think this was truly a circumstance where someone fell off the wagon, as it were, and unfortunately now he's got to deal with the consequences of that decision. Mr. Bender is gainfully employed. He's got a history of gainful employment. I reviewed the recommendation, reviewed it with my client. I think that is fair. I asked the court to hold in advance any period of incarceration as permissible by law. Also, Your Honor, in light of the extended amount of time since Mr. Bender's last conviction. I ask the court to consider less than the 3 years of supervision. I propose 2 years. I really think Mr. Bender's done very well on bond. Again, previously compliant with sobriety court. I don't think he's going to give the court or the department any issues, so I'd ask for the court to take that into consideration. Thank you. Does your client wish to address the court in light of the no contest?
I'd just like to say that it was high emotion. It was a stupid choice. I'm not going to stay here and make excuses. I know what I did was ignorant, and it was kind of a one-off. Just like I said, high emotion and acting without thinking first. And did everything I possibly can to make sure I never happen again.
Mr. Rakowski, we have
Your Honor, we agree with Mr. O'Mara's assessment. I mean, Mr. Bender successfully completed TRSC. We've had no issues while he's been out on bond. And, you know, so based on that, we ask you to consider the recommendation that was made.
Very well. Thank you. Your Honor, sorry, I forgot. I apologize. Mr. Bender he's had some medical issues again that I won't go into the details of. He had an appointment scheduled for tomorrow that he has rescheduled in light of the recommendation here today. But I would ask, first of all, the court specifically allow work release and that Mr. Bender be permitted to report to the jail in order to do so tomorrow at 6 p.m. so he can make final arrangements for work release if it's granted. Thank you. Thank you. I have a question though for the probation department. There was a recommendation for jail time, but a lot of it deferred. Was there any explanation for that? No? Okay. Well, it's a true third. There's no question about that. Prior convictions were in 2013. Defendant served 7 days in the county jail for an impaired driving. 2014, second offense, 150 days in the jail with sobriety court in place on probation. He successfully completed the program, which is significant. For whatever reason, high stress situations, whatever it may be, the defendant comes before the court on a true third drinking and driving. And obviously we hope that sobriety court would be the fallback to say, hey, look, shouldn't be doing this. However, defendant was operating a motor vehicle. And there was a situation where an ambulance was involved, and not that there was any damage or anything like that, but people could have been put in harm's way. On top of that, the defendant's blood alcohol content was of 0.24, 3 times the legal limit. And there's no justification or excuse for that, sir. Now understand, and it's real easy to say back here on the bench, but it's one thing to operate, or I should say one thing to consume alcohol. We have substance use disorders issues rampant in this country, in this world. But when you make the conscious decision to get behind the wheel of a motor vehicle with that blood alcohol content, you have no business being on the road, sir. And you have to be held accountable for that. I wasn't, frankly, the court wasn't too hip on this idea of deferring jail time, because clearly Mr. Bender should have known better, even though it was 10 years ago, more than 10 years ago, frankly. But considering the pre-sentence report, and every pre-sentence report is unique, it's not cookie cutter boilerplate language. They plot facts in and all that. They're tailored to each and every individual. And even though I have no explanation as to why the recommendation is as it is, I think I'm getting it filtered through here from counsel, both counsel, frankly, giving the court an understanding of what's going on here. But Mr. Bender, you come before this court or any court again on a life charge, don't worry about probation. You know better, sir. Yes, Your Honor. Will be the sentence this court would defendant be placed on the term of probation for 3 years. Your attorneys asked for 2, but in light of the jail recommendation, I think it's appropriate. The idea here is to have you toe the line during this time period, which includes standard conditions, not to violate any criminal laws on either the government
not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. No use or possession of alcoholic beverages or other intoxicants, nor entering bars or other places where the primary purpose is to serve alcohol for consumption on the premises. There are no substance abuse related issues other than alcohol. So I give you credit for that. However, you are to comply with all requirements of alcohol testing as directed by the field agent, not to submit any fraudulent or adulterated samples for testing, nor hinder, obstruct, tamper, or otherwise interfere with any of the testing procedures. You are to complete a substance abuse assessment, outpatient or residential substance abuse treatment as well, if referred by the field agent. You are to waive confidentiality and allow any treatment programs you're required to attend to disclose that information to the agent. You will comply with the DOC electronic monitoring program, 480 hours of community service. You have 3 years to do it. You need to get it done. No assaultive, abusive, threatening, or intimidating behavior. Not to engage in any verbal, written, electronic, or physical contact with anyone involved within an MDOC facility, nor the same type of interaction with anyone engaging in the behavior that constitutes a violation of any criminal law of any unit of government. You must not use any object as a weapon. You're a convicted felon now. You can't have, own, use, under your control, area control, weapon of any type, cannot possess an imitation weapon. Can't be around anyone that possesses those items. You're to contact the supervising field agent no later than the first business day following your release from jail or placement on probation. All written and verbal orders need to be complied with. You are to allow the field agent to your residence at any time of probation supervision, where you're subject to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you of items that violate the terms of your probation. Any arrest, police contact, loss of employment, or change of residence must be reported to the probation officer within 24 hours. You are not to operate a motor vehicle. Secretary of State will take appropriate license sanctions. You are employed, however, the standard employment requirements will be worked here as well. Crime victims assessment of $130. We'll get a due date here momentarily. Probation supervision fee, $30 per month regular, $60 electronic. Court cost of $200 payable at the rate of $20 a month. A fine of $500 payable at the rate of $30 a month. DNA testing fee of $60, $68 in state cost. Probation is authorized and empowered under statute to effect your apprehension, detention, and confinement of up to 72 hours on a reasonable cause you of items that violate the terms of your probation. If referred, you are to successfully complete any PA 511 programming based upon eligibility. Guideline range here is 0 to 9 months. It will be the sentence. This court will serve 270 days in the county jail, 30 of which be up front, the remaining deferred with credit for 1 day served. So be 29 days. We'll give you the credit up front. You can report to the county jail. Actually, this Friday, what time do you get off work?
6 o'clock.
Where are you working?
National Investigation.
But where near FedEx?
It's go over by case, so.
Okay, I know the business, but do you know where you would be specific?
We've been working regularly around Pigeon case area. It's been changing.
Can you be at the jail by 7?
Yes.
7 p.m. you report to the jail this Friday to begin your sentence.
Could I report tomorrow instead of Friday?
Would you rather?
I would.
Tomorrow it is?
So 6 o'clock tomorrow.
6 p.m. tomorrow.
Yeah, two things. Did you waive attorney fees?
I am not.
And the other thing, Your Honor, can we set a due date that the community service has to be completed by? So we don't run into issues like we have been. So a recommendation by the prosecutor's office, need that suggestion.
Do you have a suggestion regarding the date?
Usually, something like that, probably about 18 months.
Your Honor, I'd ask you, instead of we're talking a 3-year probationary term, I don't think it's appropriate for the court to require the entire balance that to be done in 18 months. Instead, I'd ask for some benchmark, perhaps half of that time to be completed by 1.5 years. Yes.
Or if we could do it a year, if we're just doing a benchmark in a year to come back and see where we're at.
That's not a bad idea either. Any problem with that? Okay. So we'll add to the probation basically a status review from the probation officer to see how we're doing regarding your community service. And if it requires a review hearing, so be it. We'll have a review hearing.
Does it take down for 1 year community service?
I would say at least half
So a year and a half?
year. We'll do a review in 1 year.
Oh.
Yeah, an informal review. It won't be on the record. Just say to review probation within 1 year, or I should say community service within 1 year.
July 13th.
July 13, court costs are due, subject to the 20% administrative fee. It's my duty to inform the defendant he has right to seek leave to appeal if he's financially unable to provide counsel of his own choice. Court will assign counsel for him a couple of expenses to initially receive a questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days.
So I'm just, I don't judgment, but I'm
Record shall reflect this. Thank you, Jack. Good luck to you, sir. Wish you the best.
Good morning once again, everybody. It's a Monday here at TCF Live. So real quick in the chat, CMS, or no, excuse me, not CMS, Joe Sears, good morning to you, sir. Talking about how, in his opinion, a first offense for DUI should be automatic prison. That's one of the things we debate a lot here on this channel is DUI and how to handle it and whatnot. I come down personally on the side of if there's no injury, there's no accident, that first one should probably be a go light but be scary kind of situation. So I don't personally think it would need prison or jail time, but some hefty fines, maybe a suspension of driving privileges for 6 months, something like that. And my reasoning for that is every one of us at some point has gone to a restaurant, for example, for an anniversary or whatever. We have 2 glasses of wine. We think we're fine. And then we go and drive. Now, some of us will get pulled over and you'll blow like a .09 or something like that. You feel like you're in control. You probably are. But you're just like barely over. You were out celebrating and something bad happens. Does that mean it was a good choice for you to do that and then go drive? No, but it's something that's common. So I'm personally of the opinion that that first one, if there's no injury, no accident, should be a little bit of a warning with like scary kind of warning type of thing. But we definitely debate that here. So I welcome your views. And good to have you because I don't think we've seen you here before, or if you have, you've been quiet. So thank you, Joe, for joining us. Let's go to down to Florida. Looks like Wade Mercer's got stuff going.
Buenos días, soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha?
Sí.
You can hear me and
Mr.
see me.
Gonzales, thank you. Mr. Gonzales, you were first appeared this weekend for 2 new charges.
Señor González, tuvo la comparecencia inicial este fin de semana por 2 cargos nuevos.
You're being brought back up this morning to make you aware that the United States Immigration Service has placed a detainer on you.
Se le está trayendo de vuelta esta mañana para informarle que los servicios de inmigración de Estados Unidos le han dado una orden de retención.
This doesn't change the bond that you were set this weekend. You still have the right to post that bond.
Esto no cambia la fianza que le fijaron durante el fin de semana. Sigue teniendo derecho a fijar esa fianza.
But if you post the bond, you will be picked up by the United States Immigration Service within 2 days. You will not be released.
Pero si paga la fianza, lo recogería inmigración en un plazo de 2 días. No lo dejarían salir.
If you don't post the bond, you'll resolve our charges first, then you'll go through the immigration process.
Si no paga la fianza, entonces resolvería nuestros cargos primero y después pasaría por el proceso de inmigración.
And what happens once you get immigration custody, I have no idea. They may hold you or they may not. I don't know.
Y lo que pase una vez que llegue a la custodia de inmigración, yo no tengo ni idea. Quizás lo mantengan detenido, quizás no, yo no sé.
Do you have any questions?
¿Tiene alguna pregunta?
Tengo que, entonces mejor pagar la fianza.
So it's best to pay the bond then?
No, I'm not saying that. What I'm telling you is if you post the bond, you'll be go to custody of the Immigration Service.
No, no es lo que le estoy diciendo. Lo que le estoy diciendo es que si paga la fianza, va a pasar bajo la custodia del Servicio de Inmigración de Estados Unidos.
I want to talk to a lawyer about what you think is best for you.
Quizás quiera hablar con un abogado en cuanto a lo que más le convenga a usted.
Do you have any other questions?
¿Tiene alguna otra pregunta?
Quería preguntar a ver si me pueden, si me pueden deportar de una vez o.
I just wanted to ask if you could go ahead and deport me.
You don't have that option when you have pending criminal charges in Florida.
No tiene esa opción cuando tiene cargos penales pendientes en la Florida.
That would be just ignoring the allegation against you, and that's not going to happen unless the state decides to do that.
Eso sería ignorar las alegaciones en su contra, y eso no va a pasar a no ser que el Estado lo decida.
Wish you the best, sir.
Le deseo lo mejor, señor.
Mr. Ricardo, I think that's the only one we had that needed your services, as far as I know. Anything else today, sir?
That's it as far as I know. Your Honor, what were the charges on this defendant, please?
He was accused of 2 counts of lewd and lascivious conduct. It looks
Very
like
well.
Judge Garcia set him a bond of $50,000 each this weekend.
Very well. Thank you so much, Your Honor. May I be excused?
Yes, absolutely. Have a good day, sir.
You too, Your Honor.
Mr. McDaniel, we do not have any friends or family in the courtroom, so we have Nathan Kroger next. And I couldn't tell for sure because the way the first appearance sheet is done, but it looks to me like he's just being brought out to made aware of the purge from Brevard County. Is that right?
Yes, sir.
So, Mr. Kroger, you were first appeared this weekend. It looks like there's a purge from Brevard County that someone didn't know about. They didn't know about. You have a child support matter there with a $700 purge. That's in addition to whatever you have locally. Mr. Kroger, do you have any questions?
No, sir.
All right, sir. I wish you the best.
Yes, sir.
Nicholas Mendel.
Your Honor, I'll just go ahead and send him back. He's not interested in any kind of plea.
So as far as scheduling, he's already been set up after he's had his bond revoked. As far as scheduling, what do we want to do with him? Put him on the jail docket, Mr. McDaniel?
Yes, Your Honor.
Okay.
And the felony arraignment docket.
Yeah, he'll go on both. So we need to give Tyndall a notice for both the felony docket and the misdemeanor docket, which will be in June the 2nd and June 3rd?
Yes.
June 2nd is misdemeanor, June 3rd is?
No, June 2nd is going to be felony. June 3rd was the moved up jail date.
Oh, June 3rd is the jail date and for misdemeanor. June 2nd is the arraignment date for the felony. That one's at 8:30. The misdemeanor date, of course, at 9. Thank you.
Your Honor, right quick, I want to address this. I know the original motion I filed to revoke his bond was just strictly based on contact with the victim. Do you want me to send you a proposed order or?
No, I took that order this morning and modified it.
Okay.
To make it based upon the arrest. And I signed the order revoking bond because that's what I did this weekend. It was signed this morning. The clerk's office may not have poured it over yet.
I see.
It was
Yes.
probably signed at, I was probably here by 7, maybe before 7. So did you get that? Did y'all get the email on that one while we're talking about it?
Yeah.
Did you understand what I was saying?
I understand.
I think if you attach a complaint to it, or if it's not a complaint, the sworn affidavit is sufficient, or you have testimony in court. But if I'm wrong about that, y'all let me know. But I don't think you can revoke a bond just because of an assertion without something under oath. That's my understanding anyway.
I got you.
I don't think I ever have before. Mr. Adams is next, State versus Curtis Adams. Mr. Adams, good morning. You were first appeared this weekend. Good morning. You were first appeared this weekend for the charge of petty theft. And
Yes,
the
sir.
judge put a hold on you for violation of probation potential. So I'm going to appoint the public defender's office to represent you this morning only in the petty theft case and ask that you listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Adams. He's going to plead no contest to the charges listed. You understand that he'll be sentenced to 60 days in the county jail. Yeah. 2 days jail credit, and a $370 fine. I think $6.99 restitution or $5.99, I can't recall. He has waived his right to a jury trial and call witnesses, and that'll resolve this case today.
Thank you. And Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
So you got 60 days jail, 2 days credit, $370. And how much restitution, Mr. Mitchell?
What I'm going to look back and see if I can find.
I got it right here too.
Pretty sure it was $6.99, but it may have been $5.99.
It was supposed at $6.99, $6.99 restitution. It'll be a civil judgment. Anything else, Mr. Mitchell?
No, Your Honor.
Mr. Adams, I'm sorry.
But that is agreeable with the state.
Thank you. Mr. Adams, did you hear that agreement, sir?
I did, sir.
Mr. Adams, is that the plea you would like to enter?
I did, but
Your Honor, we're gonna ask that this plea not be used against him in the violation of state probation. He does have defenses to it, and I think he has a valid, just cause to him. So I mean, that has to prove these allegations to violate his probation.
And Mr. Adams, you gotta be definitive. Do you want to enter this plea or not? You keep saying I did, but do you want to enter the plea?
well, yeah, see, I'm concerned about, I live here alone, all right? And I have no family here. I have no friends here. I'm here by myself. I'm concerned about my animals. I live by myself. I don't have family here, I was 2 weeks from getting ready to get off on this, be away from this, so that I can go back. Gotta go back to Illinois, so I'm not a flight risk. I know that. I'm more concerned about the animals in my home and losing my home for the next 6 months.
Mr. Adams, you're a theft risk based upon your history. You have multiple prior theft convictions, and I believe that's why the judge did what she did this weekend. You have no bond. I'm not involved in that case at all. Either you want to take care of this case today, or you want to wait and see what happens to the violation of probation. And I have no preference. But if you want to enter this plea, you got to tell me that you want to do this. Do you want to do this or not? And it doesn't matter to me at all.
Yes, sir.
Okay.
Yes, sir.
All right, I'm going to accept the plea of no contest to the charge of petty theft. I'm going to adjudicate you guilty of that misdemeanor offense. I'm going to sentence you to 60 days in jail. And Mr. Mitchell, I didn't even ask you, is that agreeable with the state?
Yes.
The state's agreeing to handle this as a misdemeanor, if you please, today?
Yes.
60 days in jail, give you credit for 2 days you've already served, $370 court costs and fine, $6.99 restitution will be reduced to a civil judgment. As Mr. McDaniel said, part of this plea is a condition that this plea will not be used against you to violate your probation. Again, that does not prevent the state from using the incident, but as Mr. McDaniel said, they would have to call witnesses if they can't reach an agreement otherwise and prove that you did this intentionally. So what you're doing today won't be used against you to violate your probation, but they still may try to use what allegedly happened this weekend. Mr. Adams, there's no probation involved in this sentence. You finish this sentence, you're through with this case, and I'll see you in 7 days. I know that's what Judge Garcia held you for, to see if they've got a violation of probation. Mr. Mitchell, please make sure the probation office is notified. Mr. Adams, do you have any questions, sir?
Do I have to pay the fine immediately? I mean,
the fine is the fine and court costs. You get a chance to work those off. You can't work off the restitution under Florida law, but you can work off the fines and court costs. So hopefully you'll get in the trustee program, get the fines and court costs worked off, and not owe those at all. And then all you would owe is the $6.99 once you get out.
okay.
All right, sir.
So I'll be here for about 45 days.
At least, depending on what happens with the VOP. Yeah, you'll be there somewhere in that neighborhood minimum. Okay.
Okay. Thank you very much.
Have a good day, sir. Mr. McDaniel, I think everything else was took care of this weekend. I don't think I need to see anybody else unless I miss somebody. That's all. Anything else from the public defender's office?
No, Your Honor.
Thank you. Mr. Mitchell, anything else from the state?
No, from the state, Your Honor.
Ms. Williams, miss anything, Mr. Goodson? Thank you. So Corporal or Officer Whitterson, whoever's still in there, Sergeant, I'm not sure who's there.
Yes, sir.
Sarge, Mr. Tyndall, I don't do domestic violence injunctions normally, but Judge Garcia has a conflict on Mr. Tyndall's case Wednesday. Does she normally do those by video, or does she normally have them brought to the courthouse?
By video here in the jail.
Okay, what time is that Wednesday?
Usually she does them at 9. But, I mean, we can do it whenever.
Well, we gotta do it whenever they've got it noticed for. Because we've got other people to be here. So let me see if it's on my calendar. My calendar says 10 o'clock.
That's possible, yeah, they're usually 9 or 10 a.m., depending on the docket, but
Okay, let's just double check the clerk system, because I don't want y'all waiting an hour or me waiting an hour. So it's 26173. Mr. McDaniel still in the room out there?
yes, yeah, he is.
I need him for.
All right, well, this is riveting to be sure, but let's move on. Judge Prill seems to be where it's at this morning. New contestant. Let's go back there.
People, State of Michigan versus Frederick Arthur McCoy, file number 2674, 26FH. It's time today set for defendant sentencing. Mr. McCoy is present, represented by attorney Michelle R. Siv. People are represented by prosecuting attorney Timothy J. Burkowski. Back on March 23rd of this year, the defendant pled no contest to unlawfully driving away an automobile. This Karen Everland prepared the pre-sentence report dated May 13 of this year. Ms. Siv, have you and your client had the opportunity to review the pre-sentence report?
Yes, we have.
Are there any additions, deletions, corrections, or objections to the report?
No.
Any objection to the guidelines?
No.
Sir, do you agree with all that?
Yes, Your Honor.
Thank you. Mr. Burkowski, any objection to the report as well as guidelines?
No, Your Honor.
Ms. Siv, what would you like to say on behalf of the defendant before the court imposes sentence?
Thank you. I went over the recommendation with Mr. McCoy, and I would ask the court to consider a sentence to the lower end of the guideline range. It was recommended that he serve 320 days in jail. We do acknowledge the guidelines are at 7 to 34 months. So I would ask the court to consider several factors. I don't believe there have been any issues while Mr. McCoy has been on bond. Mr. McCoy he's not employed, however, he does receive Social Security. So I would ask the court to consider a possible sentence of 30 days up front, and I would ask for any remaining time to be held in abeyance, and that is due to the fact that he would most likely lose his Social Security if he is incarcerated for more than the 30 days. Also, Mr. McCoy does suffer from several mental health diagnoses as indicated in the report. He is being treated for those through medication, and he's been involved with behavioral health for the last 10 to 11 years. I don't believe he would be able to receive that same type of service if he is while incarcerated. So I would ask the court to consider that as well. And again, to consider a sentence to the lower end of the guideline range.
Does your client wish to address the court in light of the no contest?
He does, yeah.
Mr. McCoy.
Yes, Your Honor. On December 31st, 2024, I was going through emotional distress. It caused me to have a severe mental health episode, which made me want to end my life. The night this happened still observed me. I don't recall physically walking outside driving away from home at all. I didn't realize until the next day the extremes that I took to end it all, and it was at that time I realized I needed help for my sickness. I was taken to Harvard Beach Hospital where I underwent psychiatric evaluation, and that was when I agreed to get myself in inpatient treatment. I was then taken to the Stonecrest Center in Detroit where I underwent an extreme 14-day intensive therapy treatment regimen, which I received new medication and got stable. I've been doing great since then, and here on behavioral health has helped me out tremendously where I'm still receiving treatment to this day. I have been sober for 7.5 years now and have been assisting in the caretaking of my roommate's 87-year-old mother who has just started receiving services from hospice. I don't feel that incarcerating me would be a benefit to anyone, but placing me on a long-term probation would be the best for everyone, because I'd be able to pay fines, costs, and restitution while still living a productive life in society where I'm not a threat to anyone in the community. I'm sorry for what I've done and been forgiven by the victim in this case, and I ask the court for mercy in sentencing them.
Thank you. Mr. Burkowski, anything on behalf of the people? This is victim rights case.
It is victim rights case. I don't know if the victim's here. Your Honor, we would ask that the court consider 2 years of probation. The guidelines are what they are. They're 7 to 34. Lower than the guidelines would be 7 months, but I don't see any reason, and we would argue that there's no reason to deviate from the guidelines. Mr. McCoy has 3 prior felonies, 15 prior misdemeanors. The vehicle, extensive damage to that vehicle. We'd also ask the court to keep the issue of restitution open. I believe the insurance company may have paid for the damage to the vehicle.
Thank you. Mr. McCoy, that is correct. This is your 3rd felony, 15 prior misdemeanors. And court is very aware of the mental health issues according to the pre-sentence report. But how I understand it is, after reading the report, it was a matter of you taking your friends or significant other, I'm not sure, vehicle. You took someone's vehicle, truck, you completely totaled it, returned it back. Roommate sees the vehicle and what's going on? It was you. And again, you have to be held accountable for the error in judgment that you made. But at the end of the day, you have to respect other people's property. It's not yours. Will be the sentence of this court. Defendant be placed on a term of probation for a period of 24 months. Conditions of probation include the standard conditions: not to violate any criminal law of any government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require. No use or possession of alcoholic beverages or other intoxicants cannot enter bars or other places where the primary purpose is to serve alcohol for consumption on the premises. You're to comply with the requirements of alcohol and drug testing as directed by the field agent, follow all the rules relative to that. No use or possession of any controlled substance unless prescribed for you by a licensed physician, nor are you to be around anyone that possesses those items. No possession of drug paraphernalia or be around anyone that possesses those items. You are to complete any outpatient or residential substance abuse treatment when referred by the agent, as well as the substance abuse assessment. You are to take your medications as duly prescribed by your licensed physician. You are to complete any mental health or other recommended treatment following assessment by a qualified community-based service provider. You are to waive confidentiality and allow any treatment program that you're attending to disclose that information to the probation officer. No assaultive, abusive, threatening, or intimidating behavior. No written, verbal, electronic, or physical contact without permission of the agent with anyone housed within an MDOC facility, nor the same type of communication with anyone that's engaging in a behavior that constitutes a violation of any criminal law of any government. You are not to use any object as a weapon, nor own, use, or have under your control a weapon of any type, cannot even possess an imitation, cannot be around anyone that possesses any of those items. You are to contact the supervising field agent no later than the first business day following placement on probation or release from jail. Comply with all written or verbal orders of the probation agent. Allow the agent to your residence at any time for supervision where you're subject to a search of your person and property, including but not limited to your home, vehicle, or computer, without the need of a warrant if the agent has reasonable cause you of items that violate the terms of your probation. Any arrest, police contact, loss of employment, change of residence must be reported to the agent within 24 hours. Crime victims assessment of $130 will be ordered by the court. The probation supervision fee will be $30 per month regular, $60 electronic. Court cost of $200 will be ordered, payable at the rate of $20 a month. Fine of $200, payable at the rate of $20 a month. Restitution is left open in this file. Attorney fees are waived. $68 in state costs will be ordered. Probation is empowered and authorized under statute to effect your apprehension, detention, and confinement of up to 72 hours on reasonable cause you violate the conditions of your probation order. If referred, you must successfully complete any PA 511 programming based upon eligibility. Finally, relative to the jail time that's being requested, I should say recommended by the department, they are recommending 320 days for 2 days credit. It will be the sentence of this court that you serve 240 days, which is the midpoint between 7 months and 12 months. Again, with the 2 days credit, First 30 days you shall serve up front. After the first 30 days are completed, you'll be released for 2 days. Actually, 1 day. 1 day. Then you will return to the jail to run another 30 day, then 1 day off, back and forth. 30-day minimum at this point based upon 3 prior felonies is rather significant to the court. And by doing so, it hopefully ensures your issues relative to Social Security. But at the end of the day, the court can just say, you know what, we're just going to shut it down and you have to reapply. So I'm giving you that opportunity, but when you report to the jail, after that 30-day stint, they're going to check you as well. Alcohol, controlled substances, they're going to test you as well for random testing. If there are any issues relative to your probationary term in this matter, then in that time frame, don't worry about your Social Security. Understand, sir?
Yes, Your Honor.
All court costs, financial obligations are due by July 13, excluding, I should say, then the 20% rate would apply. It's my duty to inform you of the right to seek leave to appeal if you're financially unable to provide counsel of your own choice. The court will assign counsel for your public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. Remand in custody of the sheriff. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Off the record.
So tonight, 7 p.m. Eastern, 4 p.m. Pacific, In the Blind with Mike and Dan. If you like TCF, you will love In the Blind with Mike and Dan. That involves me and Michael Groff, a sidebar panelist member and guest host of this live morning show when I can't do it. Why will you like it so much if you like TCF? Because it's completely different from TCF. It's not even close to the same thing. You just have to experience it. So check it out. Link in the pinned comment. It's a new show. We're really trying to grow it. So if you're not already subbed, if you could head over there and sub and set your notifications, that would be super groovy. Let's do this. Let's go to Fulton County, Ohio, getting closer to Ashley's territory. And we'll check in with Judge McBurney.
No contest as in a NOLO?
Yes, Sean. Explain now.
Okay. All right.
It's being reduced to a misdemeanor, Judge.
I see. Well, let's get on the record. This is 23 SC 191961, State versus, is it pronounced Moten?
Yes.
Rodney Moten. Mr. Moten is here in court with his lawyer, Mr. Arnold, and our prosecutor, Ms. Davis, is here. Mr. Moten, I'm Judge McBurney. I don't think we've ever met. I am covering for a judge who was covering for a judge, but we are all given the same authority to take pleas in what was originally a felony case. I know you're pleading to a misdemeanor. It was originally a felony, burglary in the first degree. And it's my understanding that you're ready to go forward with that plea. Is that correct? All right. Ms. Davis is going to swear you in just a moment. Once you are sworn in, it's important that you answer all her questions truthfully and completely. It's just as important that you let me or Mr. Arnold know if you've got any questions. I need to be comfortable that you understood everything we discussed. I bet you will, but I won't know if you've got a question unless you grab your attorney's shoulder or raise your hand or something like that, okay?
Yes.
All right, make sure you speak up so the court reporter can hear you when you're answering. Ms. Davis?
Mr. Moten, please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court will be the whole truth and nothing but the truth? Yes.
Okay, you can put your hand down. Please state your true, correct, and legal name.
Rodney Moulton.
At this time, are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medicine that you normally take that you have not taken today?
I took all of my blood pressure pills, high blood pressure and high cholesterol. Took those.
That's the only medication you take?
Yes, for right now in my
when my side started hurting from my cancer, I take the medication that they gave me.
Got it. But your side's not hurting right now.
Nah, but it will once I, start sitting and doing a lot of things.
Okay.
It starts hurting, like if I walk too far or, it start hurting because my cancer is, they say it's kind of coming back. So I got to watch my numbers. So.
Got it. Well, I'm sorry to hear it's coming back. So today, so far, it's been blood pressure and cholesterol medicine. When you take those medicines, do they make you sleepy or woozy or confused?
No, not really.
No, you feel like you know what we're doing?
Yes, sir.
Great.
How old are you and how far have you gone in school?
57, 12.
Are you able to read, write, and understand the English language?
Yes.
Are you a United States citizen?
Yes.
Do you understand that you're charged with the following offense in indictment 23 SC 191961? And we have amended the burglary in the first degree charge to that by taking. Are you aware of that?
Yes.
And that would be OCGA 16-8-12A. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer, Attorney Arnold, about all the facts and circumstances known to you in this indictment, including any potential defenses?
Yes.
Do you need more time to discuss this case with your attorney?
No.
Are you satisfied with his services?
Yes.
Attorney Arnold, do you waive formal reading of this indictment and any and all defects therein for the purposes of this plea?
Yes.
Mr. Moten, do you remember being arrested on these charges?
Yes.
Your Honor, the state's unaware of any outstanding warrants related to this matter. Attorney Arnold, are you aware of any outstanding warrants related to this case?
No.
Mr. Moten, has your attorney advised you of the minimum and maximum sentence for the charge to which you're pleading to today?
Yes.
The maximum sentence is 12 months. Do you understand that?
Yes.
Do you understand that today you're entering a negotiated plea of guilty, which means, or NOLO, which means the state will make a recommendation to the court?
Yes.
Do you understand the court's not required to accept the state's recommended sentence?
Yes.
Do you understand the court has the right to sentence you to the maximum possible sentence for this charge?
Yes.
Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? And that is true regardless of any advice by your attorney or anyone else.
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect the right to vote, to hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading to this, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand you're waiving all those rights?
Yes.
Do you understand that you may have only a limited right to appeal this plea conviction?
Yes.
Do you understand that you do not have the right to appeal directly from your plea, but if you believe there is some error, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes.
Do you understand that you have only 12 months from today for the misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes.
How do you plead to the charges in indictment 23 SC 191961? Theft by taking.
No content.
Has anyone forced you, threatened you, or promised you anything to get you to enter this plea?
No.
Is it your decision to waive these rights because you decide it's in your best interest to do so?
Yes.
Is this plea freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Your Honor, the state believes the evidence would show that on January 4th, 2021, the officers with the Atlanta Police Department were dispatched to the incident location, which is 2125 Joseph E. Boone Boulevard, Northwest in Atlanta and Fulton County, in regards to a larceny call. Officers there met with the victim, Mr. Constantine Foca, who reported that while he was in his office, he noticed that one of his tenants, the defendant, Mr. Rodney Moten, was inside his residential unit. The victim questioned whether the defendant was inside his unit, and the defendant reported that he was waiting for a friend. The victim noticed the door to his unit was open and that several items were missing. The victim and the defendant had a tenant-landlord relationship. And I believe it was like a wallet that was missing. I did speak with the victim. He did feel like there was something else going on with Mr. Moten that day. And so he was comfortable with resolving this matter. The state is recommending 12 months to serve 6 months. The defendant spent, I believe, 176 days in total. So he is satisfied that time. The balance would be suspended. Nothing further. And Mr. Moten does not have any felony convictions.
There was an aggravated stalking arrest after this, which makes up about half of the 180 days. That case went nowhere, as far as you know?
As far as I know.
As far as
It'll
you
be
know.
a different unit,
Okay.
but as far as I know.
Okay. So 12 served 6 months, balance suspended, and credit for the time he spent in.
Correct.
Understood? Okay. Are you with probation, DCS? Hi. Do you have, I know you're not pretrial services, so your view into Mr. Moten's possible criminal history is different, but do you have any indication he's ever been on felony probation? He has not. Okay, thank you. And you are Officer Finney? Great. All right, thanks for being here. Mr. Arnold.
Yes, Your Honor. My client was in his landlord relationship based on a government contract. My client had gotten a large subsidy from the government based on some disabilities. And that's one of the reasons why the victim in this matter thought something was going on with Mr. Moten. Since that time, they've had no other contact with each other. Based on this incident, Mr. Moten lost that subsidy. And so he had to struggle for a while finding housing, especially with this pending charge. That's one of the main reasons why this was such a burden on him. And so he's hoping by the resolution of this case today, he'll be able to get back on that subsidy. The court has already been made aware that he's still undergoing some serious medical issues. And he also has some additional family issues going on. So he's asking the court to follow recommendations for that reason. And as far as I know, they have had other than that government subsidy, they've had no further contact since this incident.
Okay, because that was going to be my question, Mr. Moten. It sounds like you moved out of that Joseph E. Boone address.
Well, the last judge told me, don't ever go back to that property.
Okay,
I never went back over there. He said, if I go to that property, I come in front of him, I'll never get out of jail. So I lost everything. Then.
okay,
I lost over $5,000. He kept all my stuff. I couldn't get a hold of no cop to assist me to go get my property.
to go
So I
collect your
lost
belongings.
over $5,000, and then I lost my Section 8, and I lost my apartment, and now I can't get housing or nothing.
Where are you staying now?
My cousin,
Is that the Irma Street address?
yes.
Okay, are you able to stay there longer, or does your cousin want you out?
Well, you know how cousins is, when they get tired of you, they tell you you have to go. But I always been on my own. I always had my own. So
Okay.
It kind of put me, yeah.
Well, this will close the case out. Is your plan to find your own place?
Yes, sir.
Are you able, this will not be a felony conviction. It's not even really a conviction. It's a nolo plea. Are you hoping to get back into the Section 8 category?
Yeah, but yeah, he called and told him a whole bunch of lies and everything, you know what I'm saying? That wasn't his.
Yeah, in addition to the stairway, the landlord also, because it was required to him to report everything, he also made a record of it. So that's been a part of the issue of being recategorized in that category.
Okay. All right. Well, Mr. Moten, I wish you the best moving forward, especially with your health challenges. Keep seeking medical attention. I find there's a factual basis for your plea. I understand why it's a nolo plea. I'll accept it as a nolo plea. This also was something that happened 5+ plus years ago, so it's good to move on. I find that your plea is knowing and voluntary. Knowing means you've understood the things we discussed. Any questions about anything?
No, sir, I just need, some kind of.
Yeah, I need some
paperwork
documentation. That's,
So I could try to get back into, even I can getting back into college now.
Great.
That's all this is, yeah, I want to get back into Microsoft and the internet, you know what I'm saying? That's what I wanna.
All right. Well, a lot of opportunities there. I hope you're able to do that. And you're certainly young enough to start a new chapter. And Mr. Arnold can help you get all the final paperwork that will flow from today. Mr. Moten, I am holding the indictment in your case where it says no contest and it's been reduced to the misdemeanor. Did you sign this document?
Yes.
You did. Great. That indicates your plea in the case. I'm going to sentence you, Mr. Moten, to 5 months to serve on this misdemeanor, but you'll get credit for the time that you did serve. And that's it. That'll close the case out.
Thank you.
Okay. Ms. Davis, anything else in Mr. Moten's case?
Nothing further from the state
All right,
judge.
don't run away quite yet. Mr. Arnold, anything else for Mr. Moten?
no, Your Honor, I'll make all the additional paperwork he was asking for, I'll make available to him once the court is signed off.
Sounds good. All right, now you can run away.
Thank y'all.
See ya.
Now you can run away indeed. Good morning once again, everybody. TCF Live. It's Monday. We're halfway through the show already. Michael Groff, 12 months with us now. Anybody who doesn't appreciate Michael Groff, something is wrong with your brain and you should seek medical attention. Michael is the best. Came to us a year ago. Immediately, I saw his talent. I'm so impressed by him. Over the last year, he has not only guest hosted this show, he's been a mainstay on Sidebar, a regular in our chat, a big supporter of this channel, and honestly has become one of my best friends. So, Michael, thank you for being who you are. Thank you for everything that you do for us, and you are very much appreciated. CMS, in the chat a little while ago, you were questioning, or just commenting rather, on the complexity and the knots that the legal system ties itself into, and you specifically cited the theft by taking thing. It's not the legal system that's tying themselves in knots there, it is the legislature. Specifically in Georgia, I looked this up. They define the different variations upon theft within their code. So it all stems from code 16-8-2. It defines theft by deception, theft by conversion, theft of services, theft by shoplifting, theft by receiving stolen property. It also has provisions in there for stolen goods being brought into the state, livestock theft, cargo theft, trade secrets theft, and porch piracy theft. So there is a lot that actually goes into how they define theft. And that's why they don't just say you stole something. The statute actually defines how the theft happened, not only that it was just a theft, and then the prosecution kind of defines their case accordingly. So that's what goes on there. Michael, thank you for gifting a membership. Very much appreciate that. So I just thought I would share. That is why things happen the way they happen in Georgia. Let's go to Texas now. Judge Raquel West. Isn't it interesting how so many defendants show up in safety yellow? It's like a thing.
Good morning, Ms. Young.
Good morning, sir. You are Joshua Barlow.
Yes, ma'am.
This is cause number 18-26688. Mr. Barlow is on probation for possession of a controlled substance. A motion has been filed. What is the announcement?
Judge, we did a short reset on this one because we had a court date out in Harris County. Was in hopes that they would go ahead and dismiss that one then, but it looks like we will be moved to the trial docket. I believe they're going to try to subpoena the plaintiff over there. And so I don't know how long it's going to be or when, but
But it's my
That's
understanding from Mr. Lewis, and I have no reason to doubt that based on my knowledge of that offense, Mr. Barlow, et cetera, that their subpoena of her will be against her will, and I don't intend to proceed on that with the court's permission in the motion under those set of circumstances, Judge, if that makes sense.
Right, and so do we, like, what are the other allegations? What's the?
If we could maybe at this juncture, knowing that, if we could just abandon or bypass those at this moment and have them enter pleas of true or not true, just to the administrative violations, maybe get an update, see if there is for some reason any change in that before I formally abandon it, but it is my intention and it is my understanding based on the facts of that case, that there's a subpoena of her, and correct me if I'm wrong, it's probably against her will.
Right.
Over there, I mean, are we gonna wait 3 years for him to go to misdemeanor trial?
No,
over there?
no, we're doing it here, and if
Right.
you want to get her here or try, that's one thing. If not, we're not waiting on that. So let's go ahead and go through the motion and get pleas of true or not true, and I will, it looks like skip number 1, number 2. Just those two. It looks like I have to do with that other case. Okay. Mr. Barlow, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. And will he waive the formal reading of the motion?
You would, yeah.
Get this done real quick. Hold on, sorry. All right, Mr. Barlow, in cause number 17 -26688, I have a motion to revoke your community supervision. Shows that you were placed on probation September 18th of 2017 for the offense of possession of a controlled substance, a second-degree felony. That was a 10-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
It alleges you violated your probation. Count 3 alleges that you failed to remain in Jefferson County as ordered, and that you were in Harris County, Texas, November 8th of 2025. And that was without permission of Jefferson County probation. Is that true or not true?
Yes, ma'am.
True or not true?
True.
Count 4 alleges that you failed to immediately report to the Community Supervision Department an up-to-date physical address. And is that true or not true?
That I didn't.
That you didn't tell them a new address
Not true.
where you were living? Okay. Count 5 alleges that you failed to immediately report to the probation department your arrest from November 8th of 2025. Is that true or not true?
True.
Count 6 alleges that you provided a urine sample March 4th of 2025 and April 8th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
Can you say what?
Marijuana.
Oh, true.
Count 7 alleges that you're behind in your court assessed fees as of November 19th of 2025 in the amount of $4,734. And is that true or not true?
True.
Did you enter your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm going to reset your case for a sentencing here. Pre-sentence report, else about those cases in Harris County, and then we'll come back at that date for sentencing. Are you currently wearing a drug patch? Are you ordered to wear a drug patch? Before you leave today, I want you to have a seat in the jury box. We're going to get a drug test this morning. All right, have a seat. Actually, come over here first and get a thumbprint, and then have a seat for a drug test.
That's.
Agreed. Yes, ma'am.
Todd, thank you for gifting a membership. I appreciate it. Across Judge Stevens, where parents Charles Manson Tribute Day?
Nice to see you, sir. Do you need to get your hair cut over at the jail?
Yes, sir.
Okay, we'll help you with that, okay?
Yes, sir.
Get you.
Yes, sir. Lieutenant Morgan. I'm sorry.
All right.
I'm sorry.
Xavier, you're charged here. Servant, sir, upon here and the trial day for trial, okay?
Okay.
All right, you see Joel here, Vasquez? You want to trial?
No, sir.
Go
Yes, sir.
on your own. What you're charged with a third-degree felony of aggravated, I'm sorry, assault on a public servant, which is a third-degree felony. But the indictment goes on to allege that before you committed that third-degree felony, you were convicted in 2020 in Montgomery County for the second-degree felony of illegal possession of a controlled substance. Do you recall that event? After, oh, I'm sorry, that was December 20th, and that cause number, and it's 20-02-01978, which is the way they numbered things in Montgomery County. After that conviction was final, paragraph 3 of this indictment alleges that you thereafter committed another illegal possession of a controlled substance, a second-degree felony, and you were convicted of that on June 20th of 2023, also in the same 359th District Court in Montgomery County, Texas. You remember that event happening?
Yes, sir.
After that was final, it is alleged in paragraph 1 that you then commit the offense alleged in paragraph 1, a third-degree felony of aggravated assault of a public servant. If you were found guilty of this aggravated, this assault on a public servant, rather the third-degree felony, and it says that you caused bodily injury to the public servant by striking him in the face with your hand. And he was apparently, I guess he was a jail security official, so he must have been a jailer. If you were found guilty of that crime, if it were found true that you have these prior convictions out of Montgomery County that of illegal possession of a controlled substance, then you were looking at what we call habitual felon status. Your punishment range would be no less than 25 years in prison, a minimum of 25 years in prison to life in prison. It's the most serious type of punishment other than, I guess, capital punishment. So do you understand what you're facing here, sir?
Yes, sir.
Oh, have you talked to Mr. Vasquez about whether that could be resolved without a trial or not? Because that's what we're here for. We're going to try this case unless y'all can reach an agreement with the DA's office. Have you thought about that? Why don't you talk to him and just find out what the options are, and then we're going to do whatever you want to do, okay?
Yes, sir.
Yeah.
Okay.
Go ahead.
I'll go ahead and put it on the record that I was going to waive his priors and agree to a 5-year sentence. As far as that's the plea bargain agreement.
Y'all go back and talk, okay, Xavier?
Yes,
and so what, do you understand what he's saying? It's going from, if we go to the jury, you're looking at a minimum of 25 years imprisonment if found guilty. And they're offering 5 years with credit for time you have served in custody in regards to this, which I'm not going to influence you, but that's a most generous offer. But at the end of the day, it's your choice. Whatever you do, we're going to take that route, okay?
Yes, sir.
All right, talk to Joel and come back and let me know what y'all do because y'all are up here for trial. Okay. Thank you. Do I have any pleas in the queue?
You should, y'all.
Yes.
You've been cited, so.
Is Rolando Martinez and Brayden.
Yeah. Armando Martinez, por favor.
Want me to swear?
I was doing it to impress you.
You did great, Judge.
Muchas gracias.
De nada.
It doesn't matter what.
That was Spanish, by the way, we were speaking.
Yeah, it doesn't matter what language you do. I've been here around the world with you.
And I'm proud of it too. I'm proud of that. That adventure you and I have had.
There has been.
Here it comes.
You gotta have a finger right this way, sir. Right around.
Is it flag on the office?
Let's go on the record. Does that go on the record?
Everything goes on the record, hearsay. Which means you're in deep trouble.
I know.
What can I say? You've always been.
You drop a deep way. Thank you.
Thank you. Making that type small. Let's see. All right, we call cause number 23 CR 1653, the state of Texas versus Armando Martinez. And the defendant is present with his attorney, Mr. Burbank. The state's attorney is present. And Mr. Martinez, I believe, is fluent in Spanish. And Erica Burge, our great translator, who's is fluent in English and Spanish and has translated officially for us numerous times, is present to help Mr. Martinez. Ms. Burge, please raise your right hand. Do you solemnly swear or affirm that you will well and truly and accurately translate from English that we will be speaking into Spanish, for which Mr. Martinez is most fluent, and then his Spanish responses will be repeated into English for all of us, and the record shall reflect through the court reporter. Will you do that accurately? And I know you will professionally, so help you God.
Yes, Judge.
Lower your hand. You are Armando Martinez.
Yes.
And you were here with Mr. Burbank, your attorney, and the state's attorney is here, the prosecutor. You are going to be entering a plea today to this offense as alleged, correct? No, what are we doing?
Let's
What's the
include
plan?
a manslaughter.
Stand by. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He does in your Your Honor.
In summary, this indictment, as it is alleged, that was handed up by the grand jury in October of 2023, alleges that on or about September 18th, 2023 in Jefferson County, Texas, you committed the first-degree felony of murder. Do you understand what you are charged with here in the indictment?
Yes.
Yeah.
Yes.
An agreement has been reached between the parties that you would be pleading guilty to the lesser included offense of manslaughter, which is a second-degree felony. Is that your understanding of the plan?
Yes.
All right. Crime of manslaughter is found under section 19.04 of the Texas Penal Code. And this provides that a person commits an offense if he recklessly causes the death of an individual. Do you understand what manslaughter is, sir? This is a second-degree felony, which means if convicted, you face no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
An agreement has been reached in your case where you would be pleading guilty, found guilty of the second-degree felony of manslaughter, and sentenced to 5 years in prison. Is that your understanding of the agreement? If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this lesser included second-degree felony of manslaughter under this murder indictment in this cause number 23 CR 1653? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily, that is on your own free will, and because you are guilty? Because you were guilty.
Yes.
Show you what's marked as State's Exhibit 1. Did you sign that document? Did you understand it? Discuss it with your attorney? It was translated to you from English to Spanish, and then you spoke with your attorney. Is all of this on State's Exhibit 1 true and correct? State's Exhibit 1 is tendered into evidence. Without objection, it is admitted. Among other things, this states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. And you are totally satisfied with the representation provided by your lawyer. All of this true, it states, so help you God. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
We ask you what it is.
I'm going to follow this agreement, if nothing further, and I'm going to find as follows that in this cause number 23 CR 1653, the state of Texas versus Armando Martinez. The defendant was charged with the first-degree felony of murder. He has pleaded guilty upon a plea agreement reached between the state of Texas and the defense for a guilty plea of the second-degree felony of manslaughter under this indictment. And I'm going to find that the defendant has pleaded guilty to this lesser included offensive manslaughter voluntarily, knowingly, intelligently.
I think he's a citizen. I don't know if we covered that or not.
There is sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt of this lesser included offense of manslaughter. Stand by. This, going back on this written agreement that is part of the plea agreement that you signed and admitted to, that was State's Exhibit 1, among other things. State's Exhibit 1 states that if you are not a citizen of the United States, a plea of guilty and a conviction may result in your deportation, exclusion from admission to the United States, and or denial of naturalization under U.S. federal law. Do you understand what I'm saying? Are you a citizen of the United States?
No.
Okay. Do you understand that a plea of guilty and a conviction under manslaughter can affect your ability to gain citizenship under the laws of the United States? Do you insist on continuing to plead guilty to this lesser included second degree felony of manslaughter?
Yes.
See, yes.
Sí.
I'm going to follow this agreement. Anything else is a pre-sentence report waived.
We waive, has to be waived, nothing.
If nothing further, I'm going to make the following findings. That Mr. Martinez, you are pleading guilty to this second-degree felony of manslaughter, a lesser included offense under this indictment of murder. You are doing that voluntarily, knowingly, intelligently, and based upon discussions with your attorney. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included second-degree felony of manslaughter under this indictment. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a handgun, was used in the commission of this offense. Do you understand what has happened today, sir?
Sí.
Anything else to add?
Nothing, sir.
Defense state? All right. We're in recess on this. Thank you.
So I was trying to figure out exactly what the motivation was to take him from murder down to man 2 with only 5 years to serve, and then the whole citizenship thing came up. So it's very clear now. It's get him on the lesser charge and get him out of the country as fast as possible, either for security or, quite frankly, for saving the money of housing him. So that's what was up with that. Lisa, good morning. Good to have you here. Okie dokie, let's go back up to Judge Prill. He's got a new contestant.
Present, represented by Attorney Michelle R. Siv, people being represented by Prosecuting Attorney Timothy J. Rakowski. March 23rd, 2026, defendant entered a no contest plea to domestic violence third offense. Ms. Karen Everland prepared the pre-sentence report dated May 5th. Ms. Siv, have you and your client had the opportunity to review the pre-sentence report?
Yes, we are.
Any additions, deletions, corrections, or objections?
I'm sorry, I kind of just noticed it. In regards to prior record on page 1 for misdemeanors, it says 0.
A number of misdemeanors that were not scored, or they were scored, but they don't reflect on the face sheet. So
I don't, no, it does not. It's not showing up for me. So these 1, 2, 3.
Seven. You count that as one, Ms. Siv?
Yes, I will, yes.
Mr. Rakowski, any objection?
No objection.
Pre-sentence report will make that, the correction will be made in the pre-sentence report. Any other additions, deletions, corrections, or objections?
No other corrections.
Guideline issues?
No.
Mr. Rakowski?
None on behalf of people, but we approach.
Yes. Wait. Ms. Sibb, anything you'd like to say on behalf of the defendant before the court imposes sentence?
Yes, thank you. I had the opportunity to go over the recommendations with my client, and I would ask for the court to take a few matters into consideration. Mr. Johnson does acknowledge prior history, he acknowledges that the most recent incident in regards to domestic violence was in 2024. However, I would ask the court to consider that anything prior to that in regards to domestic violence, I believe was quite some time ago. The most recent before the 2024 around 2004. Also, I would ask the court to consider that Mr. Johnson does not have any issues on the bond that I'm aware of. He is gainfully employed with a school in engineering, and he has been there since 1994. So he does show that he has a strong stability. I would ask the court also to consider that the no contact order between my client and the victim was lifted on April 22nd of this year, and I would ask the court to continue to allow that contact to continue. Since this is a recommendation that he's not having contact with his wife, but again, I would ask the court to continue to allow the contact since April 22nd. In regards to work release, I would ask for the court to allow that. Mr. Johnson works about 10-hour days, 6 days a week, and it takes about, if he were to walk from the jail to his place of employment, is about 15 minutes one way, so 30 minutes total. So I would consider that in before we're allowed to work release. There was a letter that I received from my client's mother, which I provided to Mr. Rutkowski and to the court. It was unfortunately sent to the wrong email address, so I did not get it until later. So I would ask the court to still consider that. And then they have received a letter written by the victim by Mr. Rutkowski, and I would ask for the court to strongly consider the contents of that letter as well. And all in all, again, I would ask the court to sentence Mr. Johnson on the lower end of the guidelines. The guidelines came to 0 to 11 months. The recommendation I would feel is obviously pretty on the high end. So given everything that I just stated, I would ask the court to consider a lower end there.
Thank you. Does your client wish to address the court with no contest?
Very briefly,
Sir.
I just want to let you know that I take full responsibility for everything I did. I can't believe it happened. I apologize to my wife and trying to work through things. And I bottle things in until it's closed, and that's not an excuse. I drank for the first time in 2 years, and that made everything worse. So I'm just asking for something to see.
All right, thank you. Mr. Rutkowski, on behalf of the people, this is also a victim friend's case.
Yes, Your Honor, we supplied the letter. A victim wishes you to read that letter to yourself. And she asked you to take that into account. We're asking you to adopt the recommendations that set forth by probation. The only change would be, as Ms. Sibb had pointed out, we had amended the bond back on April 22nd. So we'd ask you to delete that division of or provision about the no contact.
Thank you. Mr. Johnson comes before the court at age 50, 1 prior felony, 7 prior misdemeanors, and associate's degree on top of that, and gainfully employed. The defendant's prior history, rather old, at least relative to the first domestic violence conviction, and second. First conviction was August 31st, 2000. Second conviction was September 3rd, 2004. So we're talking nearly 20 years until the third conviction, domestic violence second, on June 27th, 2024. Defendant was discharged from probation on December 29th of last year. 1 month later, this incident happened. 1 month. And it was an argument over no drink mix in the house. The defendant had been consuming alcohol, which he acknowledges. Johnson, Ball, you should know better. You can't let things bottle up. You can't just hold it in, and then explode to where people are hurt. Now, mind you, your spouse has prepared a letter that the court has reviewed and read privately. Mother's letter as well is also being considered this. And for lack of a better phrase, this is a very sympathetic letter on your behalf. So that's to your credit. But it doesn't excuse the behavior. Drink mix. That's what this was about. This is your 4th domestic violence conviction. It will be the sentence of this court. Defendant be placed on a term of probation for a period of 3 years. Conditions of probation include standard conditions: not to violate any criminal law of any other government, not to leave the state of Michigan without prior approval of court, notifying the probation agent at least monthly or such time and place as the agent may require. No use for possession of alcoholic beverages or other intoxicants, cannot enter bars or other places where the primary purpose is to serve alcohol for consumption on the premises. He's to comply with the requirements of alcohol testing as directed by the field agent, follow all the rules pertaining to that. Complete any substance abuse assessment, outpatient or residential substance abuse treatment when referred by the agent. Complete the anger management program. How many times have you completed that previously, sir?
I think 2 times.
Hopefully 3rd time's the charm here, sir. Waive confidentiality and allow treatment programs you're required to intend to disclose that information to the agent. No verbal, written, electronic contact or physical contact with anyone housed within an MDOC facility without permission of the agent, obviously. Likewise, no communication with anyone engaging in behavior that constitutes a violation of any criminal law offending the government. Paragraph 8 is stricken. Electronic monitoring program is ordered as well. Comply with all rules pertaining to that. No assaultive, abusive, threatening, or intimidating behavior. You must not use any object as a weapon. You cannot own, use, or have under your control or area control a weapon of any type. You can't possess an imitation weapon. You can't be around anyone that possesses those items. You are to contact the supervising field agent no later than the 1st business day following your placement on probation or release from jail. Comply with all written and verbal orders of the field agent. Allow the agent to your residence at any time for probation supervision where you're subject to a search of person and property, including but not limited to your home vehicle or computer without the need of a warrant if the agent has reasonable cause you of items that violate the terms of your probation. Any arrest, police contact, loss of employment, or change of residence must be reported to the agent within 24 hours. You are to notify the field agent if you are served with PPO within 24 hours of service. You are gainfully employed, but the standard employment provision will be ordered in this case. Crime victims assessment of $130. Probation supervision fee, $30 per month regular, $60 electronic. Court costs $200 paid a month. Fine of $200 payable to rate of attorney fee. Gainfully employed, $400 in attorney fees will be ordered, payable at the rate of $23 a month. State cost of $68 will be ordered. Probation is authorized and empowered under statute to effect your apprehension, detention, confinement of up to 72 hours on reasonable cause you of items or that you violated the terms of your probation, that is. If referred, you must successfully complete any PA 511 programming based upon eligibility. And it will be the sentence of this court that you serve 300 days in the county jail, credit for 2 days previously served. You shall serve that time forthwith. I have no objection to PA 511 programming or work release. However, I must report with the Sheriff's Department guidelines. The court does take into account your spouse's letter, but sir, you were off probation not even a month when this incident arose. So you have to be held responsible and accountable for it. All financial court costs, that is due and payable July 13th. My duty to inform the defendant he has right to seek leave to appeal. If he's financially unable to provide counsel of his own choice, court will assign counsel for the public expense. He's to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the court for 42 days.
Yeah, I apologize. I neglected to ask if the court would consider a later report date for Mr. Johnson. He gets paid bi-weekly, and he wasn't initially aware of the cost for work release. So I would ask that if he be allowed to report after next Tuesday, that's the day that he would be paid next. I would have to allow.
Mr. Rakowski, your position.
We leave it to the court's discretion.
He has until Friday at 4:30. He must report to the jail Friday after work. What time is his work scheduled then? Or work end Friday?
He works from 5 a.m. till 3:30.
All right, let's report to the jail by 4 p.m. Friday. That'll be off the record.
Hour 3 of TCF Live on this beautiful Monday morning. We've had about 450-ish people come by this morning. If you're new to us, do say good morning to us in the chat. We're friendly folk here. Let's go over to Louisiana. We will check in with the parole board.
Good morning. Michelle Dozot Warden. And
Danny Henshaw classification.
Elizabeth Savage Colonel.
Commissioner Evans, Major.
Thank you. And we have before us Mr. Walker.
Yes, ma'am.
All right, just stand by a moment. We have some folks who are here to recognize those who are there and on Zoom.
Okay.
So we'll let everybody get situated. So the way this will work, Mr. Walker, is I'm going to read some identifying information into the record. I'm going to ask you to confirm whether it is accurate or not. Your case this morning has been assigned to Mr. Prater. You should see him on your screen. So after I preliminary verification, I'm going to turn it over to Mr. Walker, and he'll recognize your guest there and ask you some questions and hear from the warden, and then we'll hear from everybody that wants to speak. So just stand by.
Are you ready for me, Madam Chairman?
So we're still waiting. Here we go. We're about ready to get started.
Okay.
Yeah, Mr. Walker, you're here. Would you introduce yourself? Tell us your name and DOC number.
Richard Walker, 701-732.
All right, Mr. Walker, you're here today seeking a commutation of your sentence. You were sentenced in Jackson Parish, November 2015 for 3 counts of forcible rape, and you received a 40-year sentence. Is that information correct?
Yes, ma'am.
Okay, Mr. Prager?
Mr. Walker, I hope you're doing okay today. Yes, sir. How are you, Sheriff? I'm fine. I'm doing good. I've got a couple of folks that want to speak, and of course, one's on Zoom, and 2 are there with you. They're in support of you, and they'll be speaking in a moment. But then first off, want to hear. Tell me what you did, why you're there, and what you've done since you've been there that is going to make us of the opinion that you deserve to be released early. And then I want to hear from the warden about what kind of fellow you've been. Yes, sir. I am here for 3 counts of forcible rape. I've got a statement I would like to read if that's okay with you.
Yes, sure. It's addressed to the parole board, correct?
Yes, sir. Yes,
Okay.
sir.
Yes, sir. That'd be fine.
Okay, I want to begin by first thanking the board for this opportunity to come before you. First and foremost, I want to say that prison has not only saved my life, but it's also changed my life beyond words, because I now have freedom internally that I never would have thought possible. Upon my sentence, victims' impact statements were made, and those statements have stuck with me in the forefront of my mind since day one. Through victims' awareness, I truly began to grasp the full measure of just how many lives
affected in the trauma that I inflicted. I want to use this opportunity to show the board that I'm no longer the man that I once was. I want everyone affected, as well as the board, to know that I take full responsibility and accountability for my actions, because I know firsthand how much of an impact this has had, not only on their lives, but their mental health as well. While I know that words without action are absolutely meaningless, I pray that through me taking this step, you can see the intent of my heart. Prison has changed my life, and I want to thank you from the bottom of my heart, because without prison, I would not be free, whether physically or emotionally. This experience has changed my life, and I've wanted to express this for a while now. I know that y'all see this a lot, but I no longer deny what I did. I take responsibility, because in order to bring closure for everybody, including myself, a man has to take responsibility for his actions. And from day one, I have taken class after class. Even though I don't get good time, I still took classes, not for the fact of a parole board, but to better myself. And I hope that shows.
Okay. Well, thank you. I appreciate that statement. That checks a lot of boxes, and we'll have some more questions in a little bit. Warden, would you tell us what kind of fellow Richard has been since he's been there?
Yes, sir. He's been here since 2015, the end of 2015. He hasn't had any rule violation reports. He's not a behavioral problem in any way since he's been here. He's very active in our chapel services. He handles a lot of the music with our outside guests, and does a lot of that internally for the inmate population as well. I've also seen him assist in mentoring some of the younger and challenged individuals, that are a little bit more vulnerable to other scenarios. And so he's kind of been able to help them just make sure that they're not getting in anything they shouldn't be, and letting staff know if they need some assistance. So he's no behavioral problem. He is an active leader and member in our chapel services. He's also completed the entire sex offender treatment program, living in balance, victim awareness, and I think every class that we've offered here. So.
Okay. All right. Thank you very much. We appreciate that, Warden. We value your input. Okay, let's hear from, I think your father, your sister, and your mother are going to be speaking this morning. Your father and your sister are there. Let's get your mother out of the way from the Zoom, and then we'll move back to the room there. So Miss Debbie Russ is the mother of Richard Walker. Would you talk to us on Zoom, please?
Yeah, if I can get this here camera to work right. Hey, everybody.
Good morning.
How are things going?
Give your statement.
Your statement.
Your statement.
We can hear you fine.
Okay, I'm not exactly sure what I'm supposed to say.
Well, you're supposed to say whatever's on your heart that's going to cause us to want to feel like that he's done the appropriate steps to be released early.
Okay. I have been amazed at the change in this young man's life since he's been walking the journey that he's walked. I've seen a tremendous change in him. I've seen him go from a young man, or a young boy actually, to a man, making decisions that have not been very easy. And he's been very quick to share things with me that he didn't have to share, but he's trying to stay honest, and he's trying to do things that need to be done. And not only that, but I've also seen a tremendous change in his heart and his walk with the Lord. And that has meant a lot to me. I do know that there are things in life that can't be changed and can't be reconciled. But you know, God is a God of forgiveness and a God of mercy and a God of grace. And I've seen a tremendous change in him. I've seen him go through things and endure things that have happened to him in the past. He's had to work through and walk through, as we as a family have done, and loved and supported him. And I'm encouraged to go with him from here to see what God has in store for him.
Okay. Thank you. Thank you for those words. We appreciate that. Thank you very much. Okay, we'll hear now. We'll move back to headquarters there, David Wade, to the room there. And we'll hear from Mr. James Walker, the father, and then we'll hear some from Alicia Walker, the sister. So, Mr. Walker, would you talk to us, please?
Yes, I am James Walker, and I'll refer to him as Daniel because that's what I've called him since he was born.
Okay.
So Daniel and I didn't have the opportunity to bond in his young adult or pre-adult years. His mother and I divorced, and we didn't have a closeness that I look back and say I wish I had as a father. Then my career took me far away to New Jersey when he reached young adulthood. It was soon after that Daniel was in prison. That's when we began to bond, and he started communicating with me as a dad, and recognizing that some of the things that I had done in my life were not easy, but I had accomplished those, and he seemed to want to learn, how do you work through that? What I've seen is a young man who has acknowledged some really, really bad choices and some bad behaviors. I did not know that he had a serious alcohol and drug pre-prison. And I've learned that he's acknowledged that and knows that that is something that affected his behavior, his thought process, and kept him from moving forward. What I've seen in the years that he's been here is he has begun to understand what it is to be an adult, what it is to take responsibility, what it is to set goals. And he's taken the work that he's done here with the chapel and the things that he's been allowed to participate in seriously like a career, and use those things to learn how to, hopefully someday when he gets out of here, build a life. He also has talked with me and acknowledged that building a life outside of here will be very different than it would have been had he never been here. That's going to be a challenge for him, but he understands that to do that, he's going to have to accept that his life here and his record is going to limit some of his abilities. And I think he's prepared to do that. We've talked about goals and housing and financial responsibilities. And Daniel was never a financially responsible person. I think his mother can probably attest to that as well. But one of the things that he did that really has stuck with me is when the COVID release money was given to inmates, he kept a small portion of that to take care of things without asking me for money. And he had the prison send me a check to put that aside so that someday when he got out, he had at least a start to put things together. And he's never asked for that money for anything. And he set that aside. So he's got a goal. And he seems to have at least the basics of a plan, and they've taught him so much about being a responsible and regimented person, and how to build a schedule and set some goals. And I believe that he can take that outside of these walls and figure out how to navigate as a responsible and a person who's accepted his behavior has changed his life. Honestly, I have to say, it hurts that I didn't get to be a part of what you guys created in my son, but I'm so proud that he stepped up and became that person.
Good. Very, very good words from the father. We appreciate that. Let's talk to the sister now. Miss Alicia Walker, would you talk to us and tell us what's on your mind?
Well, I've seen a lot of change in Daniel. I'm sorry. I'm emotional. I've
Okay.
seen a lot of growth in him, with his thought processes and his, outlook on life. I agree with him that prison did save his life. I'm proud of the man that he has become, and I will always be there to encourage him and support him. I would, he's done a lot. He's taken every advantage that he can in taking classes and becoming an integral part of the chapel here. And he's grown a lot. And I'm just proud that he took advantage and became a different man and a better man because the decisions that he made led him here. And I don't think he would be here without having been sent to prison.
Finish or?
All right. Well, thank you, ma'am. Appreciate those words from your sister. And now before we circle back around and talk to you, Mr. Richard Walker, I'd like to ask, could we have an executive session to discuss some other matters in this case, and then we'll come back. Could I have a motion?
Yes, sir.
We have a motion by Mrs. Stapleton. Can you call the roll, please?
Renassa,
Yes.
Freeman,
Yes.
Prater,
Yes.
Tillis,
Yes.
Stapleton.
Yes. So we'll be in executive session for a few moments to discuss confidential matters. Stand by. We'll be right back.
All right, we will come back to the board after they exit their executive session. But in the meantime, let's go back to Judge Stevens because it looks like Charles Manson is making a return visit. So let's see what that's all about.
Back to the money. Say in this happens. You're getting free for a long time.
Oh, this is Xavier
Yes, sir, it is. Just trying to get on.
in.
No, right, these straight to the right.
24 CR 1941 is called the State of Texas versus Xavier E.N. Aguiar, and that is you. Correct, Mr. Aguiar?
Yes, Mr. Judge.
Present with your attorney, Mr. Vasquez, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, Mr. Aguiar, this indictment alleges in paragraph 1. Are we just doing paragraph 1?
The only paragraph one.
All right. Paragraph 1 alleges that on or about July 29th, 2024, Jefferson County, Texas, you committed the third-degree felony of assault on a public servant, namely a Jefferson County Corrections Officer. Do you understand what you're charged with here, sir? Oh, this is a third-degree felony. If convicted, you face no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
The agreement's been reached in your case that you would be pleading guilty
Right.
and sentenced to 5 years in prison. And you would be given credit for all time you have served in accordance with that case. Is that your understanding?
Yes, Judge.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
I understand, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Correct, sir.
I'm going to show you what's marked as State's Exhibit 1 there. Did you sign that document?
Yes, sir.
Understand it?
Yes, sir.
Discuss it with your attorney. Are the contents all true and correct?
They're all true and correct.
States Exhibit 1 tendered into evidence.
Object.
Without objection, admitted. The states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true. It states so help you God. States Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
If nothing further by everybody, I'm going to follow this agreement, Mr. Agnew. I'm going to find, sir, that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from States Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this third-degree felony as indicted of assault on a public servant. I am following this agreement. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice prison for a term of 5 years. You will be given credit for all time you have served. Do you understand what has happened today, sir?
Yes.
Anything else?
That's it.
Good luck. That is all. Thank
Thank
you.
you.
Yes. No.
Yes, sir.
Okie dokie, friends, let's go back to the board. It looks like they're exiting their executive session now.
We're ready for regular session without objection. It's 9:37. We'll be returning to regular session. Mr. Prater. Mr. Prater, we're back in regular session.
Okay. All right, Madam Chairman, I am somewhat handicapped here, and so I would turn it back over to you to conclude. I have no other questions of anyone, no other procedural matters, so I'd make a motion. We go back into regular session.
All right, yes, sir. Without objection, we are in regular session. So are there any other questions for Mr. Walker? I don't see any questions by any board member. So Mr. Prater, I think we're ready for your vote.
So, Mr. Walker, I appreciate the things you said in your interview, and I appreciate the growth that you've experienced and the ownership of the crime, the victim awareness that you've displayed. However, I think that because you took a plea bargain of 3 of 10 counts that were offered, you took pled guilty to 3 of the 10 counts, and because you got a 40-year sentence, I don't think that you've served enough time in 10 years or 12 years of that 40-year sentence to be up for parole or allowed out on parole with the type of crime that you committed. I want to wish you well, keep going and doing like you're doing, but at this time, my personal vote is that your parole be denied.
Mr. Freeman?
I concur with Mr. Prater, the heinous nature of the crimes and only serving 12 years. I hope he keeps doing what he's doing, but in my opinion, it's not time for him to be out. So my vote is to deny.
Mr. Schultz?
Due to strong law enforcement and victim opposition, my vote's going to be to deny.
Please state.
Okay, Mr. Walker, according to the numerous victims that you had, child victims, you were a child sexual predator. And I consider you a continued threat to society. Your pattern of behavior was that you were a trusted individual, which that's what falls in line with a child sexual predator. You've only served about a quarter of your plea bargain, which it was a heinous crime. So because of the heinous nature of the crime, not enough time served, law enforcement and victim opposition, my vote today is to deny.
All right, Mr. Walker, you received 4 votes to deny your application for clemency, so that's the outcome of today's proceedings. I do appreciate the positive remarks by Warden Dozak and the work that you've done with the chapel, and the work you've done on yourself. Keep that up, but today your application for clemency is denied, sir.
Yes, ma'am.
Denied.
And I don't think anybody here in this group probably feels bad about that. Let's go back to Texas and Judge West spend a little time there.
Davis?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She does.
Ms. Davis, in cause number 25, DCCR 1450, you're charged with a second-degree felony offense of assault on a peace officer, and that's from May 19th of 2025. And how do you plead to that charge?
Judge, it is a reduced charge.
Oh, I'm sorry.
Yes, Judge.
Y'all gotta
Sorry.
stop me before I get too far. Hold on a second. Let me withdraw everything I just said. So it's the class A, just a regular assault.
Resistance.
All right. It's pulled up right now. All right, so Ms. Davis, in cause number again, 25-1450, the state's elected to proceed on the lesser included offense of a class A misdemeanor resisting arrest. And that's for May 19th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for a 1-year deferred probation. And there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State offense number 1.
Location, Judge.
It's admitted. Is there any evidence that Ms. Davis is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 1 year. You're ordered to pay that $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you have a conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed and you'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty of the offense, and you could be sent to the Jefferson County Jail for up to 1 year. Understand? All right, I've handed you the trial court certification that shows you've waived your right to appeal since I followed the agreement. You need to stop and talk to probation or have a seat in the courtroom until she's ready to call you up. She's at that desk right there. So just watch for her to call your name. She'll go over your paperwork with you. All right. Bless you, ma'am. Thank you. All right, we've got Eric Segrist. Are y'all ready on that? All right, Mr. Lewis, it's a sentencing.
Judge, I guess before, this one was reset from the previous sentencing was rejected or had us come back. He has told me this morning he's paid Mr. Kimler and wanted to review everything with him prior to things being formalized. I just want to let the court be aware of what it is.
Well, we reset it so that the victim could be here. It's my
Right.
understanding that she's here today. I'm not inclined to reset it again. I don't know if Mr. Kimler's intended to be here today, but he hasn't filed anything with the court.
Is this a consultation for Thursday? Because
No, we're going forward today. We're gonna go forward. So obviously your case has been pending for some time. Mr. Lewis worked out a probation deal for you. I just want, before we go forward with that, I wanted to reset the case so that I could hear from, Ms. Munoz with regard to some of those allegations about, contact. So this is 25 DCCR 1836. We were previously here. Mr. Seacrest entered a plea of guilty to the second-degree felony offense of burglary of a habitation. The agreement was for 10 years in prison that was to be probated for 5 years with a $500 fine, conditions that would go along with that. And we've already been here on sentencing once. You guys both have had an opportunity to review the pre-sentence report. Any other additions, corrections to that report?
Not from the state.
Not from the commissioners.
Now, other than the issue with regard to some of that contact allegations, is there any reason not to go forward? Anything else?
Noted.
All right, so if you'll get Ms. Munoz, you can question her. Stand right over here. There you go. Right up there.
Right here, just,
You can just come right
just
here.
stay right here.
Good morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You can put your hand down. Mr. Smith?
Okay, would you state your name for the record and spell your name for the court?
Carla Gisela Munoz, Perla Gisela Munoz, Munoz.
And you were the victim of the burglary of the habitation that we're here in court for today.
Correct.
Would you describe to the court the relationship that you had with the defendant?
It's my children's mother, ex-boyfriend,
How long were y'all together?
15 years, maybe 14, 15 years.
How long before this did y'all break up?
It's always on and off. It's never really just an on and off thing.
As far as intimate relationship?
Correct.
Do you plan on staying with this defendant?
No.
When's the last time you were with this defendant?
The last time I seen him, communicated with him.
Sir, don't talk.
It was on his birthday on December 13th, 2025 was the last time I hung out with him.
And you came to our office and you spoke to me and Ms. Kendrick before this case played. Is that correct?
I don't recall.
You remember coming into the office?
I
and
remember
meeting?
coming in, I don't know if it was before or after. I remember I spoke with y'all.
Okay. And then you
Um,
remember being contacted by the probation department when they were preparing
Yes.
the report for this case?
Yes.
And since the time that he pled and got out of custody, has there been any issue with the defendant?
I've had some vandalism going on at my apartment, my vehicle, my apartment got spray painted, and where I used to work at, up the road, it got spray painted as well. With my name.
Okay, so a place that you used to work when he last had contact with you, correct?
Yes.
So the place that you used to work, the apartment that you live in, and your vehicle,
Has been vandalized since.
would you describe that vandalism for the court?
So I have like 2 X's on my apartment right next to my door. I had 2 X's on my vehicle. And at the car wash, there was my name spray painted with 2 X's, and it also said TikTok. With a rose or a flower right next to it.
And all that was after you came to the district attorney's office and spoke.
Yeah,
to
it was
Ms. Skinner.
after, yes.
So those marks, were they virtually identical in all 3 of those places? With the addition of the flower and the TikTok in your name at the place of employment?
Yes.
Your former place? of
Yes, they all had the same like 2 X's symbols on them.
Did you go to that place of employment after those marks were put?
Yes, I went up there because well, one of my coworkers had my phone number and sent me a picture of it. And it was the same spray paint that was spray painted on my vehicle and my car.
Same
In my
color?
vehicle and my apartment.
Same color?
Same gold color.
Did you have an opportunity to observe the surveillance video at the car wash?
Yes,
Did you see the person putting those marks at the car wash?
yes, I saw the whole video. They have
And
video everywhere.
do you see the person in the courtroom here today that was doing that damage, at least at the car wash?
Yes,
Who was it? Would you point to him and identify an article of clothing that he's wearing? Here in
The record will reflect she's identified the defendant, Mr. Segrist.
Do you, did you have any problems with anything like this before he was released from custody?
no. I didn't have any issues.
And what do you want to happen? in this case?
I just want to live my life and just move on. I don't interact or try to, make him upset or anything. I just avoid him with all contacts.
And you have children with you,
Yeah.
so y'all will have to have some kind of contact.
There's other ways to work around that with his sister or his mother. We don't have to have any contact.
So you just are requesting from the court no contact whatsoever with
Yeah, I
the
don't want no
defendant.
contact.
Any questions of the witness? No, you
Just-
don't get to ask questions.
Just briefly,
Go ahead.
you said you saw the surveillance video from the car wash. And now describe for me that was just a painting with your name and the two X's, that's correct?
Spray paint, yes.
Right. Was there any video or surveillance footage to this vandalism to your property?
No. I don't think my camera caught it on time, but I did have neighbors a few doors down that said that they saw him. That was the only people that told me that they saw him.
Okay, so other than a few neighbors, there's no direct evidence that any
No,
potential
we don't.
damage
No
from
evidence.
Mississippi. That's what.
Anything else?
Nothing, Judge.
Thank you, ma'am. You can go have a seat.
So, sister, whatever she did.
Can she be excused?
Yeah,
Judge?
sure. Yes, ma'am. All right. Mr. Smith? Thoughts?
Judge, based on his criminal history and the acts after he got out of custody, I'm reluctant to go along with the deal, although the defendant mainly has told me in conversations outside of this, as well as today. that
The
she-
witness, you mean?
I mean, the witness, that she just wants to be free of him and not have any contact whatsoever with you.
Mr. Lewis?
Judge, I think, even from the witness there, I think there's enough vehicles there that any contact that they make would have to have with each other in regards to their children. There are other people that they can step into place of that, so they won't have to have any, contact. And I believe, of course, some type of no contact or anything, as a condition of probation.
No contact, and we've at least got, these allegations of the vandalism give me a lot of concern. So, obviously, looks like he's on camera on one of them, and it would be highly unlikely that he's on camera with the same color spray paint, painting the same things, and not the one that did the car and the house. That doesn't make any sense. So the fact that he was at her house where he wasn't supposed to be, at a work where he shouldn't have been, and vandalizing those things is very concerning. And not something that I think is indicative of somebody who wants to have a relationship with his 3 children, because he can't follow the rules while he's waiting on court on a second-degree felony where you go to prison for 2 to 20 years. Does that make sense?
Yes, ma'am.
So all this, I mean, what good does vandalizing and putting her name out there, what good do you think that's gonna do?
I mean, I've never vandalized any of the stuff. Anything that I've ever done for her was to help her. When
So you're saying that it's not you on camera?
I looked at the video, she sent the video to my sister. The guy that had the spray paint was spray painting with his right hand. And I saw the video and
So some random guy out there is doing all this and not you?
there was another guy.
All right, here's what I'm gonna
There's
do.
another guy that went by her apartment.
Stop. Here's what I'm gonna do. Mr. Segrist, I'm going to I'm gonna follow the agreement, but I am going to order a condition so that we can have hopefully some better thinking processes going on at some point. So what I'm gonna do, Mr. Segrist, today is find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement and find you guilty of burglary of a habitation. Sentence you to a term of 10 years in prison, but probate that, you'll be on probation for 5. You're ordered to pay the $500 fine, and you're ordered to follow all of the conditions of probation. One of those is that you are going to enter and successfully complete the cognitive track of the ISF program. You will go into custody today. It is a 90-day program. And then when you get out, you'll be on probation, required to follow all of the same rules and conditions, which include having absolutely no contact or communication with Ms. Munoz. And that I'm also going to order, as soon as you're out, that you have to have a GPS monitoring device on at all times. If it's not charged, if it's taken off, I will find out immediately. There will be a warrant for your arrest, and you will be back in here with a motion to revoke and look at it going to prison for that 10 years that you just agreed to. Do you understand?
Yes.
I'm going to hand you trial court certification. Shows that this was an agreement that I followed, and so you have waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. If you have questions, talk to Mr. Lewis about that. And if you have any questions about how long it lasts or what the rules are, you can talk to him. All right, you can go back with the bailiff.
Alrighty, friends, let's head across the hallway to Judge Stevens, and I believe we'll finish our day off with him.
Mr. Jones. Yes. Got you. Safe yourself, right? What are we doing on these?
Judge, I need to swear in.
We on both or one?
We're pleading on 2, dismissing 1. There's 3.
Really? I didn't see that.
Should be 3 cases, Josh.
Harper.
No, it's Pratt Jackson.
Yes, I know.
Oh, okay, I thought you.
What I'm holding there.
Oh, I don't know if I'm right. Yeah, you got to.
Patterson, Sanchez, Hassan, Bailey, Madison, Bombona, Dias. No harm. You sure?
Richie with his.
Yeah.
Much stronger. Yeah, right there. No, that's good.
Uh-oh.
Travis Jackson.
Yeah.
You look good.
Can't find that.
Have two on my eye.
At 24, 354 and 355.
0093, that's missing.
No, that's all I have. This is Travis Jackson, right?
Yes.
No, there's only 2 cases.
I have a 24 DCCR 0093.
I don't have, that's not on this docket. It's just 354 and 355 on this docket.
Right.
What's that other one all about? What is, See, I've got assault and taking,
Separated from the other ones, Judge. I got,
Yeah.
I got place, but
what are we gonna do with it? That third one?
That's on the plan, that's one, that's not the
Okay.
main ones.
Turn the volume off for a minute.
Hmm. We are back on the record. We have three cases, the state of Texas versus Travis Jackson. And first one we will deal with is 24 CR 354. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed?
Yes, Your Honor, please.
In summary, this indictment alleges that on or about January 18th, 2024 in Jefferson County, Texas, you committed the second-degree felony of assault on a peace officer. Do you understand what you're charged with here?
Yes, sir.
A third-degree felony means you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached where you would be pleading guilty and sentenced to 5 years in prison to run concurrently with 24 CR 73 and another case, 24 CR 355 will be dismissed.
Yes, sir.
Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Correct.
How do you plead to this, guilty or not guilty?
I plead guilty.
Are you pleading guilty voluntarily and because you are guilty? That's a question. Yes. Are you guilty and because you are guilty? Correct?
Yes, sir.
And 93 is the other one.
Yes, sir.
Yes.
24 CR 93 is called. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
Yes, please, Your Honor.
In summary, this alleges in paragraph 1 that on or about November 29th, 2023 in Jefferson County, Texas, you committed a third-degree felony of obstruction or retaliation. It says that you intentionally or knowingly threaten to harm another by an unlawful act, namely assault and or murder in retaliation for or on account of the status of the victim, a person who had reported the occurrence of the crime. You understand what you're charged with?
Yes, sir.
This is a third degree felony. Again, if convicted of a third degree felony. Stand by. You face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand that?
Yes, sir.
And an agreement here in this case shows that soon you would be pleading guilty, sentenced to 5 years in prison to run concurrently with the preceding case. And again, 24 CR 355 would be dismissed.
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this
Guilty.
charge in 93, third degree felony of obstruction of retaliation? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I'm going to show you in each of these cases what's marked as State's Exhibit 1. Did you sign those documents voluntarily? Understand? Discuss them with your attorney. Are the contents all true and correct?
Correct.
State's Exhibit 1 tendered into evidence in each of these cases.
No objection.
Without objection admitted. The state you're mentally competent to enter your guilty pleas, they're freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You read them. You were guilty of the crimes charged in any lesser included offenses. You were giving up your rights to a jury trial and the rights to appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
In each case, State's Exhibit 1, part of the record for all purposes without objection.
Okay.
Is it so? Pre-sentence reports are waived?
Yes, please.
On each of these cases, 24 CR 9-3, the third degree felony of obstruction or retaliation, and 24 CR 354, the second degree felony of assault on a peace officer. I'm going to follow these agreements and find that you, Travis, Nicholas, Jackson, in each of these cases, you have pleaded guilty voluntarily. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. Each of these cases from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt of these offenses. I now find you guilty beyond a reasonable doubt of the offenses, a third degree felony of obstruction or retaliation in 24 CR 9-3, and the second degree felony of assault on a peace officer in 24 CR 354. And following these agreements, you are hereby sentenced in each of these cases to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. In each of these cases, these sentences shall run concurrently. Do you understand what has happened today, sir, in each of these cases?
Yes, sir.
Stand by. Okay, I've got a dismissal in one of these, right?
Yes, sir, and I'm doing it right now.
Order.
You're leaving now?
I think she's got to be the files. There's nothing put there. Okay. Here we go. Yeah, it's a good sign. Good one. Did some. Yeah. Can I have witness on the one for the super very, very.
Did you get it? Nothing yet. She sent, I would dismiss that. Point, of course, CR 355 is here not dismissed. I think that takes care of everything.
It does.
All right, that is all right.
Alrighty, friends, and that takes care of our programming for this morning. Tot, by the way, I forgot to thank you for that other gifted membership. And Moon, congratulations on receiving it. That hardly happens, very rarely happens, where somebody who is live in the chat gets gifted a membership. We'll be back tonight over at In the Blind with Mike and Dan, 7 p.m. Eastern, 4 p.m. Pacific. Please do check that out if you stick here. YouTube will send you over there right after the show so that you can set your reminders and your notifications, and subscribe if you haven't already, and all that happy stuff. As well, we'll be back tomorrow morning, 9 a.m. Eastern, 6 a.m. Pacific, a half an hour earlier if you're a channel member. Also, look for videos to be posted here throughout the day today. Thank you all so much. I look forward to seeing you all soon. Go have yourselves a great day. Take care. God bless.